My apologies. Um, Representative McKenzie has brought forward a bill about the 66 and two-thirds, um, changing the rate to 66 and two-thirds. We want to discuss whether that's feasible or at our current 60% reimbursement rate is good. And just to take a quick overview of both sides of that discussion. Um, Representative Sullivan, do you have any questions or?
No, I just would, in many respects, I'm going to be deferring to Representative McKenzie. He's the one who's sponsored both of these bills and has done a great deal of background work on it. I understand we get one vote, but we get two heads.
That's okay. No, the more people at the table, the better. That way, everybody has a clear understanding of where we are and why we're here.
Yep, perfect.
Yep, thank you. Who wants to start off explaining the gentleman from NCCI?
Thank you for following hold.
Yeah.
For those of you who do not recall me from February, my name is Nathan Fennessy. I'm an attorney at Preddy Flaherty. I represent NCCI, which is the National Council on Compensation Insurance. We don't take positions on bills. While I'm wearing this orange tag, I don't actually lobby on behalf of NCCI, but I do represent them in the state and try and provide information to the various stakeholders. We are responsible for the voluntary loss cost filings, and we're also involved with the residual market.
Mhm.
So we did an analysis of Representative McKenzie's bill. At the time that the analysis was done back in January, we did it based on what we were told would be in the bill. There was an amendment that I don't know that was actually adopted, but essentially we assumed certain aspects of it, which was, for example, that it would begin in January 1 of 2026, that it would not be retroactive to claims that previously been submitted, and then we did the analysis. So the estimate that we made based on the proposed change is that it would result in an impact of between plus 5% to plus 6.3% on the current voluntary loss cost for 2025, which is about 12 million to 15 million in additional premium expenses. That was just for the voluntary market. It did not include self-insurance. It did not include self-insurance, although we did have a footnote where we sort of flagged based on other people's data approximately what that number might be. Again, we can't really speak to it because we don't handle that market. We don't do an analysis of that, but we want to give you sort of an order of magnitude of what the potential impact would be. I don't know if you want me to get into the details of how the calculation was performed, but there's really three different elements to it. There's actually four elements, because there's four different things you're looking at. One is the permanent total disability, the permanent partial disability, the temporary total disability, which is essentially the same from a accounting standpoint as the temporary partial disability, and then you've got the fatal claims. Obviously, the fatal claims, there's no impact of this change other than some additional cost, but it doesn't impact utilization. We included a factor for utilization for the permanent partial and the temporary total disability, which was really just the temporary partial disability aspect of that, again, because they're calculated the same, we sort of use those terms interchangeably, but it's really the two partial aspects where, based on some research that NCCI has done in the past, there's an expectation that if you increase the indemnity benefit, that there's going to be some increase in the utilization of claims. Basically, the idea that someone with some sort of a partial disability may stay out on workers' comp for some additional period of time, which would result in an increase in just the indemnity portion of that. It would not necessarily impact the medical portion, although it could. Because this change just relates to the indemnity portion, that was what we were focused on. So we did that and then prepared sort of an upper and a lower bound based on sort of what those utilization rates might be. And then for each of those different categories. And then and those numbers were essentially for the permanent total disability, it's going to increase indemnity between 9.5% and it's just 9.5%. The permanent partial is 11.9% to 14.5%. The temporary partial disability would be 12.8% to 16.6%. And then if you add those all together, we got 12.2% to 15.3%. But then because the indemnity benefit's only 41% of the cost, we had to apply that, and then that's what gets you with the overall cost impact of plus 5% to plus 6.3% on the premium.
Can you just speak quickly about what the 60% is now of what they receive compared to the 66 2/3 if we changed one from a full rate of pay to a net rate of pay?
So if I understand your question, the 60% right now is the employee's pre-injury weekly wage, which is subject to a maximum of 150% of the state's weekly wage, but then it can't exceed 100% of the employee's after-tax weekly earned.
Representative Sullivan.
That's a lot of numbers.
It is a lot of numbers.
I see you've got the benefit of a document to lead you through this. It would be swell if we had the benefit of a document.
This is actually the analysis that we sent to everybody back in January that I'm just reporting.
And I failed to print it out, so I don't have it. Okay.
See if I had it.
So we do 60% of their gross pay right now, and then we would have to change it if we did 66 2/3, would give them a 10% increase, yet would change the trajectory of their funds. I mean, your funds, your indemnity funds, immensely.
Are you asking, would that be a 10% increase to the individual's wages? I believe it would still be the 6 2/3% more, which is essentially, 10%, give or take.
Yep. All right. Any further questions for Representative McKenzie?
Thank you. I think it's important to put this in context in the sense of the trend over the cost of workers' compensation. And I know you had done some analysis of that and showed what the increases and decreases were, but that's right. I think you shared that with us.
I did.
So can you just put that on record again in terms of what the workers' comp rates have been doing? And I don't know if you have 5 or 6 years, whatever the case may be, because I think if you're looking at an increase, that's against what has been a trend, I believe, of decreases over the course of a number of years.
Sure. So I know I shared at least with, I think, the chair and maybe the vice chair, and I know Representative McKenzie, This is from the voluntary loss cost filing. I just took a sheet out of this is the filing for 2025, just to kind of put things in perspective. So in 2025, it was a 5.6% decrease from the year before. In 2024, it was 13.9% from the year before. In 2023, it was 7% decrease from the year before. In 2022, it was a 8% decrease from the year before. In 2021, it was a 1.8% decrease from the year before. 2020 was a 9.6% decrease, and 2019 was a 14% decrease. So generally speaking, we have seen over time, and this has really been a product of essentially, for the most part, sort of the severity and the number of claims going down over time, which has led to the overall cost of workers' comp going down.
So if you had all those numbers up, what's the average decrease over a period of time? You're better at math than I am. So.
If I had a calculator, maybe I could do it. I'm not. I'm not a mathematician, but yes, there. I would say that there has been, largely, with the exception of 2021, which was primarily was a result of COVID. It's been going down at least 5.6 was the smallest decrease in the last 6 years, with the exception of 2021.
Thank you. And you only handle the voluntary market, correct?
Well, we are involved. We do the rate filing as well for the residual market. So that's much smaller. I'm sure Christian could probably speak to how big that is. What we don't do is we don't do any of the self-insurance.
Okay.
So we don't handle any of that.
Sounds good. Thank you. Mr. Bragdon, do you want to join us? You're self-insured and you have a time limit? You heard the discussion so far
Yes.
and your thoughts, sir.
So for the record, Peter Bragdon, representing the Lawson Group, which is a third-party administrator for a number of self-insured funds. So I think, I'm not an expert on this per se, and certainly Attorney Fennessy knows the number side of it and the underlying underpinnings of it. I think from a bigger picture, philosophical stand, at least for the self-insured groups, I think a priority is placed on, as I've said in various hearings before, one, making sure the accident doesn't happen in the first place. That's the best way for everybody. But then if not, the primary goal is to get people back to work as quickly as possible. And so I know that in talking with my client in the past, various studies have shown that if somebody does not get back to work within X number of days, then their chances of ever coming back in any way are significantly reduced. So, it's a balancing act. You could, if you paid an indemnity rate of 100%, then there's less incentive to come back to work because the 100% is covering it. On the other extreme, you pay 0%, but that's really to no benefit to the injured employee at all. So there's a balancing point somewhere in the middle that helps both sides achieve some objective, and we're certainly comfortable at the 60%. I think to some degree, even to the effect that the lack of income tax actually makes that comparable to other states, maybe at a higher level. But the fact that the number in people's minds is 60 and not 66, just a further incentive to work hard to get back to work. Our goal is to get people back to work and help reduce those claims costs and keep people whole as well. So that's just kind of the big picture from our perspective.
Thank you. Any questions for Mr. Bragdon?
So you mentioned and the gentleman from NCCI mentioned as well, this decrease in claims overall. Can you attest to that? Do you see that in the work that you're doing, that the safety and health has impacted the comp rates? And the reason I say that is because part of the deal that was struck with 1409 was to build into 1409 at labor's request better safety and health conditions to save people from getting hurt. So is your sense that it's going down?
Thank you for the question. I guess I can't speak to exactly what's going on, what the histories have been. I heard what Attorney Fennessy said from NCCI. But I do know from our perspective as self-insured, we spend about twice the percent of premium on loss control and loss prevention than a typical commercial carrier would spend. So our focus is definitely, keep the accidents from happening and thereby help everybody, the employees as well as the employers. But in terms of exactly what's happening in the market and the rates, I'm not familiar with that.
Thank you.
Thank you. Oh,
Thank you, Mr. Bragg. See the insurance guy, yeah? Thank you for joining us.
Hi, my name is Christian Citarella. I'm Chief Property and Casualty Actuary at the New Hampshire Insurance Department.
You heard our discussion, and can you just give us a little feedback on what a change in rates might do to carriers in the state, or increases or decreases or something like that? And how
Yeah.
many carriers do we have in the state?
Individual insurance, workers' compensation insurance carriers writing in the state somewhere around 100, probably more. Some of them have very, very small piece of the market. Oftentimes, workers' compensation is kind of an add-on. Like carriers want to sell property coverage, they want to sell commercial auto, and so if an employer has, hey, can you take this workers' comp, and they'll say sure, as long as it meets some of their expectations and their risk appetite, they'll write it. Some of the businesses that have some of the more risky occupations that they do, voluntary market just won't take it. And so, or if there's a loss history there that is just adds risk, or in certain situations, if it's a new business without really a loss history, then the voluntary market just, doesn't have that appetite. And so then the employer then has to turn to the residual market, which makes up less than 6% of that bucket of employers that look to insurance carriers for workers' compensation insurance. As Mr. Fennessy mentioned, there has been these loss costs have been going down for the last decade or more. I think it's something like 60% in aggregate. So 12 years ago, if they were paying, if there was $100 being paid for claims, both the medical side and the indemnity side, we're now looking at $40 of what the $100 was paying, 12 years ago.
Can you just speak quickly about the residual market, and if we change that, would that be?
Yeah, I have every reason to believe that, there would be a comparable or parallel change to the loss costs in the residual market to the voluntary market. They generally behave the same way.
And the residual market is more for people that have had issues in the past, or a new business,
Yeah.
or have had multiple claims and they drop into that bucket.
Right. I mean, we can't in New Hampshire, we don't force insurance companies to take on risks in the workers' compensation world. And then that residual market mechanism that we've chosen, that the legislature put in place decades ago, was this pool where the losses, profit and loss is shared by the market as a whole. And then it's administered by 3 servicing carriers that are insurance companies themselves that have a designated crew of adjusters and managers that handle, the premium and loss that comes in from these employers.
So it's just 3 companies that handle the residual.
Yeah, I
market.
mean, as they're essentially TPAs, they're third-party administrators.
Thank you. And are you aware of the 60% and the 66 and 2/3, the difference
Mhm.
between having one at a gross pay, one as a net pay? Do you think?
That is new to me. I don't know what you mean by net in that regard.
Does we have the 60% we do of gross wages right now.
Right.
Other states do 66 and 2/3 of net wages after taxes and everything else too. Any knowledge on that?
No, I'm not aware of that.
Okay.
My understanding is that it's gross just about everywhere.
Thank you. Any further questions? Oh, Representative McKenzie.
When we started through workers' compensation reform many years ago, you were probably in grammar school. um, the conditions were, there was actually one person left in the state that was doing it. You just mentioned that there are 100 companies currently writing. Can you characterize the market in terms of healthy, profitable? Do you have any comments in terms of what the market looks like today compared to where we were prior to many of these reforms?
I would say we have 6 or 7 main lines of insurance in the property and casualty world. Personal auto, homeowners, and then on the commercial side, you have property, you have auto, you have general liability, those sorts. I would say workers' compensation is probably the healthiest of the markets. It is the strongest of the markets. Insurance companies it's been profitable for at least a dozen years.
And is that because of less claims that you guys wouldn't see those necessarily, right?
Yeah, I mean, it's a number of reasons. As Mr. Fennessy mentioned, the just frequency of claims has been going down. The costs for each claim has been going down over those years. And also insurance carriers, and 2 decades ago, there was much concern about medical costs in the future. And so there was a lot of reserving on behalf of the insurance carriers. So essentially they would expect medical inflation to go up a lot. And medical inflation has not gone up as was expected. And so many companies were reserving back then and anticipating a much greater increase. So 20 years ago, a worker would get hurt in 2005, and they would expect that person to have to require some surgeries down the line, right? For example, hypothetical situation. They were trying to reserve, and that's kind of the work that needs to get done, because you need to post the full cost of that claim at the time that the claim happens. This is what reserving actuaries do, and they have to anticipate what it's and adjusters need to anticipate the full cost of that claim. In 2005, they were seeing at the time double-digit, medical CPI, and so they were anticipating that claim was going to cost a lot more than it turned out to cost, 15 years later, and they were anticipating, potentially multiple surgeries for that claim, and it turns out that, maybe there didn't need to be as many surgeries, or the surgeries weren't as expensive as they once anticipated. So what happened was insurance carriers were able to release some of those reserves, which helped their bottom line, because if you release reserves, it appears as if it becomes like a negative paid loss or a negative incurred for that particular claim, and so they're saving money along the way, and so the year over year costs of the company was going down, and so that too, and then that helped inform some of the reserving going forward for the new claims that developed in the early 2010s. And so those incurred losses were less at the time of the loss. And so that helped, also bring down the overall cost of insurance. Was that, medical costs, which are more expensive in New Hampshire than in other states, aren't as bad as they once thought they might be.
Good. Representative Solow?
You said that If the costs aren't realized, they're lower than anticipated, reserves are released. A released reserve, is that like profit?
I mean, it's just, it's, it's a negative incurred loss. So,
Where does it go?
it, yeah, I mean, ultimately it can go to the bottom line. Yeah.
Okay.
It increases surplus for the
Just
insurance
trying
carrier.
to cut
Yeah.
through the lingo.
Yeah.
Any further questions? Very good. Representative LeBray.
So that money, to Representative Sullivan's point, isn't coming back to the business owner in any capacity or the policy holder.
If it might, if the carrier then has adequate surplus that can release a dividend, some workers' comp insurance carriers do, issue dividends to their policyholders if it's a mutual company.
And with like a class code, could that potentially be less the next year? I don't know if that's your question to ask you or not, but when we write, there's different class codes, as you know.
Yeah.
Would that class code, say it was $100, would that maybe be 90 if there was a surplus next year to whoever took the policy?
To my understanding, it doesn't get that specific. So, and the dividends are just these one-time payouts at the end of the calendar year. So it would go to, it would get distributed to policyholders. And then some carriers have some complicated formulas that they use in order to distribute those dividends, where it will depend on kind of the experience of those employers, those policies. So if the policy had some losses during the year, then they wouldn't enjoy the dividend as much as some of the policies that might be claim free. And so, in that case, it may depend on sort of those class codes, but the dividends are independent of the loss experience and the premium, those loss costs that are determined for the following, policy period for the next year. The shorter answer, I suppose, is that yes, the experience by hazard groups, so the more dangerous jobs, as experienced by losses in the prior 3 to 5 years that NCCI will look at the loss experience, will then translate into higher, if necessary, or a smaller decrease in loss costs going forward. Yeah, so it does, the challenges of each class code do affect it, not on the dividend side so much.
Just one follow-up. Have the dividends ever been paid out in your history? Have you ever seen that?
Oh, sure.
You have?
Oh, yeah. Yeah. Yeah, and it's carrier by carrier. They have their own internal determination of when a dividend ought to be paid out, and they have governing rules within, the board of directors for the insurance company has to then declare the dividend, and but it happens. Yeah.
I can tell you, I've never seen one.
You should go ahead and ask your carrier if they.
I've never seen the dividend either. So now I'm just curious about this whole process. If these losses are way less than what they predict, is there a way as a consumer that I know that is if my insurance carrier has all this extra money kicking around, how do I even know that?
You can, I mean, it's going to be written up in the annual report for each insurance. Yeah, each insurance company has public reports.
Representative McKenzie.
So if I ask you, generally speaking, workplaces are safer, would you agree with that?
Yes, relative to 20 years ago.
Yeah.
Yes.
And would you agree that that hasn't had an impact on the overall cost of workers' compensation? Would you agree with that?
That's generally been the trend as provided by the data by NCCI.
Great, thank you.
Yeah.
Any further questions? Thank you. If you'd like, yeah. I always have the department go last so they can back clean up.
Okay, if I dare. So for the record, Mike Summers, President, CEO of the New Hampshire Lodging and Restaurant Association. My experience is very specific. We have a nonprofit self-insured workers' compensation trust program. that does very well for our members. Representative Avalani, I believe your business would qualify, so maybe you want to talk after this, but we do have dividends. Couple things that I think are worth mentioning here is, when you get to your rate, you were asking about your rate per class code. Your modifier is the piece that really affects where you end up paying, because the class code is really set by the general trend in the market. And then obviously your modifier, your experience based on injuries, claims, et cetera, then can jack that up dramatically, because you can be less than 1 and you can be much higher than 1, which can have a dramatic difference on what your actual rate will be. But I will say that from the workers' comp side, for our trust side specifically, we've seen our rates come down for the last 6, 7 years, 8 years at this point. But that's due to some internal things that we've done. Board of Trustees, we've worked very aggressively on safety, making sure that our member businesses are becoming very understanding of how their rates are set and what drives those rates, and how important it is to make sure that they have safe operating environments and there's no slip and falls and silly things like that. Obviously, our industry is very heavily for small injuries, right? Little nicks and cuts with the kitchen, those kinds of things, which aren't huge claims, and every once in a while we'll have something serious. But the other thing that I think has really driven costs down across the market, though, has really been the rise of the small urgent cares locally. Because when a lot of folks were going directly to the emergency room, you were paying full boat emergency rates, and that was a big cost driver for a lot of the workers' compensation claims. But now that there's all these urgent care businesses that have popped up in the last, less than 10 years, thereabouts, we encourage all of our businesses to send their employees to a local urgent care. We've set up arrangements with them, and that has really had probably the largest impact that we've seen on the actual rates that have been charged across the industry, has been just because of their ability to deliver that service to our employees at a much lower rate than the emergency rooms were doing it. So I'm not sure if I can answer any questions, but that's just kind of our unique perspective on this topic.
What is your length of utilization at 60%? Where do you find that they're out 2
Yeah, I
months,
don't
3
have
months?
that number off the top of my head. I'd have to actually ask my actuary for that. I don't have that with me today.
Okay.
Yeah, but I could certainly get that for you.
Thank you. Any questions for Mr. Summers?
All right, thank you.
Thank you. Please.
Morning. Thank you, Representative Avalati. I'm John Reynolds, State Director for the National Federation of Independent Business. I think other folks have covered the topic very well. I just wanted to offer 2 quick points. The first of which, right, is that the trend in loss costs is not necessarily always reflective of the trend in premium paid. And so when we go talk to our small employer members, we represent 1,700 businesses in the state overall, lots and lots of small employers with, between 10, 20, 5, 10, 20 employees. After business taxes, workers' comp costs are one of the first things that we hear, the second thing we hear from them. And it's not just always in high hazard industries, right? Or at least not ones that I would think of as high hazard industries. I was visiting with a gentleman who employs 7 people doing car stereo sales and equipment. And although I didn't have a real sophisticated sound system in high school, it took me back to the high school parking lot, in the early 2000s, late 90s. So it was a fun experience, except that he had a cat and I'm allergic to cats. So it was kind of a tough visit. Anyway, he's been in business for 27 years. He's had one workers' comp claim the entire time. It was some time ago, more than a decade ago. And, after business taxes, the second thing he said was, my workers' comp costs keep going up year after year after year. Now, maybe he needs to shop around for a different carrier, perhaps. Maybe stereo installation is more of a high hazard industry than I think, although I don't, think it's not like manufacturing or construction. But I just did want to stress that trend in loss costs is not always reflective of a trend in downward premium for everybody. And then the second point is, right, when we talk about why are losses decreasing and claims decreasing because of safety improvements, at least in large part, who's paying for the safety improvements? In most cases, it's the employer, either directly or indirectly. So we given that it's a very common concern for our members, or given that high workers' comp costs are a very common concern for our members, we have a keen interest in making sure that costs stay in check. Thank you.
Do you, where workman's comp, where is that usually on with most people? Where is that? Is it in the top one, top two, top three?
If you're an employer, a small
employer,
employer, for top 2 or 3 for sure. Every business that, almost every business that we go to, it's a top 2 or 3 issue for them.
Thank you. Oh, I'm sorry, Representative McKenzie. My
thank you.
apologies.
You mentioned, you 1,700 companies, is that what you said you represent?
1,700 members in the
The
state.
Can you just give me an overall nature of who you represent, the type of businesses you represent?
Sure. So in total, 90% of our members have either no employees, so they're self-employed, work for themselves, or they have fewer than 20 employees. And the average member has 10 employees, earns $500,000 in annual, or has $500,000 in annual sales. We run the gamut. We're not industry specific. The kind of main qualifier, right, is that to be an NFIB member is you're small, and then you're also privately held. So like we don't represent big businesses generally, but one of the main criteria is, right, you have to be privately held. You can't be a publicly traded company to be a member of NFIB. But we run the gamut from, flower shops to small manufacturers to landscapers to, if there's a member that makes custom scrapbooking cabinetry. And he sells, he's got 40, he's not in this state, but I know him from other work, but he's got 45 employees. He makes custom scrapbooking cabinets. He was a former engineer, and his wife really wanted a scrapbooking cabinet to maintain her materials. And so he started it, and then her friends wanted one. And then all of a sudden he's employing 40 people, and he ships to like 35 or 40 different countries. Just crazy things that you just never think of as being saleable products. But, that's what our members do.
Representative McKenzie.
So you said you represent a lot of people in single companies.
Mhm.
One person, they don't have any employees to speak of. If I'm not mistaken, I'm dragging this from way back, but I'm not sure they are required to take workers' compensation.
No, and when I'm speaking of the top workers' comp cost being a top 2 or 3 complaint, I'm speaking just of our employer members, not our non-employer members. So
And when you break down the employer numbers, further questions, Jim, I'm sorry. It would be interesting, you represent, for instance, construction companies and things like that.
we have construction members.
So, further question. So those mod rates are basically set by the insurance company, correct? So if you're a roofer, your mod rate is much higher than if you're cutting grass. And so employers who are in that type of business are probably going to see a higher mod rate. It's a reflection of what they're doing, correct?
Right. And you're right. And the example of the car stereo installer, right, is somebody who I wouldn't have thought would have, an upward trajectory over the course of 20 years in their insurance premium. And again, maybe there's something there going on there that I don't see, or, we didn't discuss, but it's not just the high hazard industries that you would expect.
Well, I'd be interested if NCCI had any comments about that, because what you're saying is an industry have no injuries or anything. Why is it that those costs are going up? Additionally, why don't they get money back when the costs go down? Thank you.
Thank you. And the department, if you would.
Good morning. Thank you for having me. I'm Danielle Albert with the Department of Labor. I think the folks who have answered questions and provided information prior to me have been pretty thorough. So maybe where I'll start is a little bit more from where the Department of Labor and what their involvement is in workers' compensation. We're not as involved with the rate settings, or with premiums. We're involved in 2 primary contexts. One, the overarching regulation of benefits as paid by any form of insurance carrier, be it a self-insured insurance carrier, which is a group of insurance carriers who are regulated through the department as opposed to through the Department of Insurance. and overseeing the payment of all of those benefits. So I know NCCI has provided some information and kind of touching on the self-insureds for a moment. You know, the way when self-insureds, when an entity, whether it's a group of entities or an individual employer who's seeking to self-insure, there's a process that they go through to become certified to do so through the department, and that includes provision of actuarial studies that are performed by actuaries. I'm not an actuary. I'm going to just say that right now. So I'm not well versed in the mechanisms of how you do those projections. We do look at those studies. They provide that information, and then there's like a certain confidence level that we're looking for them to have security with the department to essentially assure that if something goes wrong, there's money there to handle those types of claims. So that's how the department is involved. Brief overview of how the department's involved in the regulation of the self-insureds. Insurance departments, I think, obtaining that information more from the voluntary carriers, whether or not you're talking about a self-insured or voluntary carrier. If there's a claim and indemnity benefits are at issue, that insurance carrier is responsible for making payment of those claims to those individuals. So as I understand, some of the discussion is really about, you know, currently we're basing those payments on 60% of the gross wages. There's been some discussion about gross versus net. Currently it is based off gross, so it's the before tax, pre-tax earnings that are looked at. I'll note the legislation that was proposed this session left the gross in place. It was not a net calculation, so I've not really contemplated what that would kind of look like. I would note, if there were an eye towards going to a net calculation, there are other sections of statute that would need to be looked at to amend the way that average weekly wage is calculated. It's section 15 that dictates that, and right now that's where the gross comes from. Kind of by overall context, if there were a change to 66 and 2/3%, what does that set at the end of the day? It sets the compensation rate that's paid to the injured worker. Again, regardless if you're being paid from a voluntary carrier or through a self-insured structure. Compensation rate impacts a couple of different benefits, and I'll defer to NCCI on if this factored into their analysis. I cannot recall from the January analysis if other forms of benefit were included. But compensation rate also dictates how permanent impairment awards are paid, how you calculate those. And it also could have some impact on how second injury fund reimbursement works, because if you have an eligible claim for second injury fund reimbursement, indemnity is one of those benefits that can get reimbursed back to the insurance carrier / employer for that eligible claim. So if that indemnity rate has changed, that will change what the fund is reimbursing. There's a give and a take there with the fund reimbursements. Medical costs have nothing to do with indemnity. I know NCCI spoke to that. And I think maybe Department of Insurance as well. Indemnity rate does not impact or touch on medical costs. There's a separate section of statute that dictates how medical costs are paid. And I'm happy to answer anything that I may be able to answer.
Representative Sullivan.
We're talking about gross versus net income in terms of doing the calculations. In an earlier conversation that we had, it sounded like moving from gross to net would create some complications for the department in doing calculations. Could you expand on that?
Yeah, I mean, I think it would certainly alter the way that the department does it. Currently, the majority of individuals who are out on some period of disability are being paid either what we would call total disability or some form of partial disability. And again, they come in kind of different tiers, but the mathematics for them are the same. By and large, the majority of those individuals, you're looking at the gross earnings going backwards up to 52 weeks from the date of injury, and then dividing to get the average weekly wage and then paying 60%. And that's I think a relatively simplistic mathematical exercise. You're taking the wages. Now, wages can encompass a variety of things, but you're taking those gross wages, totaling them, dividing, multiplying by 0.6, and that's going to set the compensation rate. If you're looking at the net earnings, you're now looking at those after-tax earnings. And I guess it would depend on how it were constructed. If the insurance carrier, through working with their insured, is responsible for getting a hold of those wage records to report to the department, we would take that report, and again, depending on how the calculation were altered, could simply add them up and then still go through the mathematical exercise. I would see some potential concern if gross wages were still provided to the department and then we were either having to send them back to folks and saying, please take out the net, or you've got to get a hold of those net wages, the after-tax, those after-tax wages so that the calculation can be provided. So I think it would depend on how it's constructed, but it could complicate the calculation either for insurance carriers and what they need to receive or to the department, depending on who has the onus in coming up with those numbers.
And is it fair to say that it could create some delays while you're going back and forth between insurance carriers, employers, and so on?
I think that's fair to say in any scenario where the department receives a submission. We certainly, under current structure, receive what we call memos of payments, but the insurance carrier's submission of those calculations they're doing under the current construct, where they have made errors or have not included what they need to include, we then have to reject it back to them. We give a set time frame for them to respond. And there can be a delay depending upon how long it takes the insurance carrier to take our technical suggestions on trying to correct, or if they need to get more information from their insured. So it potentially could.
Representative LeBray?
Regarding claims, how many per year do you guys usually see? Would you have a number for maybe last year, using that as an example?
Yeah, that's an excellent question. I will ballpark it because I
Yeah.
don't have them exactly with me. And I'm just going to give the caveat of we don't necessarily track claims in the sense, the way that the department conceptualizes claim may be different than how insurance or NCCI does. We're looking at first reports that are filed with the department. So the caveat I'm going to give is not every first report results in a compensable claim, because that claim may be denied for very valid reasons and not challenged, or may be challenged and ultimately determined through the hearing process not to be a workers' comp injury. I want to say on average within the past year or so, mid 30,000 to 40,000 first reports per year.
And one follow-up, if I could.
Follow-up.
Just out of curiosity, as we traveled through COVID, did that number go up or down, or did it stay stable?
My recollection was it was somewhat of a dip in like the 2021, 2022-ish time frame and then stabilized. What we did see were, I think we saw fewer disputes. We saw an increase or some changes in indemnity disputes that came forward because there were more questions raised about whether or not somebody was out of work as a result of sort of the world being different, as opposed to being out as the result of a work-related disability. So the nature of some of the disputes had altered. I don't know that we have solid numbers or can say quite clearly that we saw a reduction in sort of specific types of claims being forwarded, such as medical bill claims or permanency awards that may be due.
One follow-up comment. The reason I ask
Yeah.
is everybody was remote,
Right.
for like 2 years. And I just wonder if, as we stay with everybody continuing to be remote, at least 50% of the world, it seems like, maybe less, is this a big deal as we travel forward, this 60 versus 66%? Is this a player? I guess
Yeah.
is what I'm trying to ask.
That's a good question. I mean, as it relates to remote work, if you have an employee working remotely from home in New Hampshire, the employer is still going to be required to have workers' comp coverage to cover them. And injuries are a very multifactorial, very vast realm. It can be anything from your kind of, I think, standard, I tripped, I fell, I hurt myself. It can be, positioning type injuries. So typing at a computer or poor posture that results in strains or sprains or carpal tunnels or ulnar tunnel or I think they call it tenosynovitis is the tennis elbow. So there's yeah, it's a tough one, but there's a multitude of different types of claims. So working remotely, I think, a very long-winded, so forgive me, way of saying it is working remotely is not necessarily, you can still have injuries that happen and those can be viable, compensable claims. So I don't know that would necessarily, I don't know what that impact would look like. Certainly in the past several years, there has been more remote, more working from home. And we've not seen, I wouldn't say that we've seen spikes or decreases in injury reports. That they've been relatively kind of consistent.
Representative McKenzie?
I was working on a remote bill a couple of years ago, and I went to the administrative services office, and sat down with a nice group of people during the COVID. And much to my surprise, they said there was one case. When all these people were out
Mm.
and remote, there was one workers' compensation, and they said, like, we think there was one. So to speak, so I don't know what happens to the money
Mm.
when there were no, so remote workers may potentially could have an impact on workers' compensation rates, and I don't know how they calculate that, but that's not my question.
And I think it's a fair point. I mean, in order, the department can only operate off the information that we receive. So if employers in any sector or realm have injuries that they're not reporting, the department's not going to know about it. And I would hazard, or I would put out there, if you're not reporting to the department, you're probably not reporting to your insurance carrier, because there is a requirement in existing law that if, you have to report to the department within 5 days of an injury occurring, but also simultaneously notify your insurance carrier unless your claim falls within the first aid exception, in which case you only have to tell the department. So, certainly if there are employers out there who have people working remotely but are not reporting injuries, we therefore would not know about it. But the requirement is there that if somebody hurts themselves while working at home and brings that forward to the employer is required to report that, notify their carrier. Again, whether or not it's a compensable claim, that's a very different analysis, but
Work is work.
work is work.
Follow-up?
Thank you. I would just ask you to give your opinion on this. At the time, the 66 2/3 was reduced to 60%.
Mhm.
In the same breath, the law reduced the length of benefits from 350 weeks to 262 weeks. The same law, the same proposal that passed. So what is the impact on a worker that goes from 350 weeks to 262 weeks for total benefits? 'Cause that's
So
a total length of time they can be out, 262.
under current iteration, total can go on for life. So for those individuals who have those injuries that are severe enough that they have that they are meeting the criteria to be on total disability benefits, there is no time frame that ends those benefits. There are time frames that apply if you go off of total benefits, to reasserting the right to go back onto them, and that's a 4-year window from when you go off to go back on. So there's a statute of limitations that can run on total in that regard. But we've certainly administered to claims through the department where the person has been on total until the day that they pass. And then if there's dependents may then be able to come in and assert a claim for dependents benefits. The 206, is it 62 weeks, is in relation to those partial benefits. So I think that's the change that you're referencing. That change took place before my time. So while I'm familiar with it, I wasn't there for any of those discussions. But in effect, what did it do? If an individual either starts out on total or convert or is on partial benefit, meaning that they have regained some form of work capacity that translates to an earning capacity. I can work reduced hours, or I can go back to some form of work, but I'm not able, as the result of the residual or ongoing work-related disability that I have, to earn at my average weekly earnings at the time of injury or higher, because certainly you're more than whole if you can get to higher. The insurance carrier is going to be liable to continue to pay you a partial benefit, which is calculated currently at 60% of the difference between your current earnings, and that's done on a weekly basis, and your calculated average weekly wage. That time frame, that 262 weeks, if you are on that partial benefit when you get to that 262nd week, when you transition into your 263rd week, you're, by automatic operation of statute, no longer entitled to indemnity, and the insurance carrier can file with the department to cease payment or notifying us that payment has stopped by operation of law. I'll acknowledge I'm not that familiar with what it was pre-change, because I think that was 20 some odd years ago, and it was before my time in the comp realm.
It's 1994.
1994. Was that about 20 years ago? I don't, it was some time ago. 30? Oh, man. Oh, goodness. But it does create, there is a cutoff point now for those folks who are partially disabled. So if you are in that partial disabled category, you may not be back to 100%. You may not be able to earn at your average earnings at the time of injury as a result of your compensable work-related injury, but your entitlement to those indemnity benefits ends. It does end. That does not impact your other benefits. Your medicals continue. Your entitlement to permanency, if you haven't yet received one, or if you have an enhanced permanency, continues. But that one will terminate. And if you're beyond that 4 years, you're not going to be able to assert going back on to total disability benefits either.
Follow up?
So, can you speak to lump sum
Mhm.
and how that, you can't lump the medical side. That's, you're there
Correct.
forever.
Correct.
But you can lump the indemnity
Correct.
portion of it. So if you're out and you're not coming back to work,
Mhm.
insurance companies can approach you, correct?
Correct.
And ask you to take a settlement.
Correct.
Do you-
On compensable claims only. So there either has to be a voluntary acceptance from the insurance carrier that we are agreeing this is a comp claim for which we have liability. If there is not that type of agreement, i.e. if the insurance carrier has denied the claim and has not reversed their denial, the department won't sign off on a lump sum because of the way that the statute is constructed. And again, that gets you to the medical portion remaining open. You cannot by law settle out the medical portion. When insurance carriers and injured workers resolve their disputes by way of lump sum settlement, they do file that agreement with the department. They have to go to a hearing, which, a series of questions are reviewed. The settlement itself is reviewed. And there has to be a breakdown that's provided that lump sum settlement is quantified as X number of weeks of indemnity benefits at the individual's compensation rate. And sometimes it includes permanency. It kind of depends on the person's injury and what it is that they're settling out.
But that, I haven't heard anybody talk about that.
Yeah.
The potential impact
Yep.
that lump sums have on the overall
Mm.
cost of insurance. And whether or not that is significant enough to pop up in the rate reduction. So, and I think there'll be a lot more flushing of that out.
Yeah.
We need that, but that's real.
Yeah.
That
That's a
happens in the department.
Yeah, it's a good question because, as noted, that lump sum settlement is premised on resolution of the claim and resolving all benefits other than medical. So that, like I said, the primarily what you see broken out in a lump sum settlement is the resolution of the indemnity claim, which could be, again, dependent upon the severity of the injury and how the parties have elected to settle, 10 weeks of indemnity, 80 weeks of indemnity, but that indemnity is set at your comp rate. So if the compensation rate has altered, it's then going to alter the mathematics for how the lump sum settlement amounts are reached, inclusive if you're settling permanency, because a permanency benefit is calculated. There's a statutory table. There are certain parts of your body which, if permanently injured, you may be entitled to this additional payment. It's not indemnity, it's a permanency payment. But the statute sets a table of the number of weeks, essentially, that the body part is worth. And then dependent upon the percentage of injury that you have to that body part, you're going to calculate out that percentage at that compensation rate. So there could be impact to the lump sum sector. Those numbers may change. What that overall impact looks like, I would maybe defer a little bit more to NCCI because I think they have better information, perhaps than the department does. But you could see changes, certainly.
And one final question, if I could. There was an attempt to rein in medical costs over the course of the years. And I'm not as up to date as I should be on this, but I know that there was more than one attempt to come up with schedules of benefits, allowable costs. Do you have any idea of where is that now? That whole, and maybe NCCI would be better at.
Currently, New Hampshire doesn't have a fee schedule. I think you're
Fee
referencing,
schedule,
yeah,
that's what
the
I was trying to get
initiatives.
at.
And please, this may not be accurate. My general recollection was the last bill trying to bring, that brought forward a fee schedule was maybe around 2017 or 2018 and was not successful. So currently, New Hampshire does not have a fee schedule. Fee schedules set like certain dollar amounts that certain types of medical services can be charged for. What New Hampshire has is what we call the reasonable value of service section at section 24, which creates a mechanism whereby an insurance carrier on presentation of a medical bill, first of all, they are required by law to take that bill. They have 30 days to review it and review treatment narratives or whatever it is that they need to look at to determine voluntarily whether or not we believe we are liable for this bill. If their agreement is, yes, voluntarily, I think I'm liable for this medical service, this directly relates to the injury for which we own liability, they have to, at a minimum, pay what they've assessed as the reasonable value of that service. And there's quite a few factors that insurance companies look at in determining what that reasonable value is. I would defer maybe to Mr. Bragdon on some of the machinations that they look at in determining that. They then have to pay that amount, and then the provider can dispute the balance of the bill if the provider doesn't believe or disagrees that that's the reasonable value. They have to try to resolve their dispute before they petition for a hearing, but ultimately, if they're unable to resolve their dispute, they can have a hearing at the department, and ultimately the department will render a determination as to whether or not was the reasonable value paid, or is there anything in addition due. The burden is on the provider in those situations to demonstrate that the charge being asked for is the reasonable value. I'll note the department has not, I think in the grand scheme of workers' compensation contested disputes that we have, reasonable value of service disputes is not one of the higher numbers. The majority of workers' compensation disputes that are brought forward, that either hearings are requested for or actually go to hearing, are really in relation to causation. Is this a work injury at all, or medical and or indemnity benefits? But instead of a fee schedule, that is what New Hampshire has instead, is this reasonable value system.
I think one thing occurred to me.
Last one.
Thank you. There were a number of things built in by statute to the and responsibilities built into the work that you do as a result of these reforms over the years. So can you just tell us in terms of how the department approaches the safety aspects and how proactive they are in terms of safety? Because there was a lot in the legislation that required them to do a number of things within the department, including publishing reports on a regular basis.
Yeah, I think what you're referencing are the sections that are at 64 in the workers' comp statute. So those are that section is in relation to the joint loss management committees and the filing of the safety summary forms. So it's a requirement under the workers' compensation statute. It's really the department's inspection division that goes out and engages with all employers. It's a requirement for not just public employers, because we also have a safety sector that's specific to public employment. But all employers who have 15 or more employees are required to abide by those requirements at section 64. So it is something that we engage with, that we educate about, that if we interact with an employer and they don't have either the forms on file and or the JLMC convened, that we work with them with. There are certain penalties attendant to failing to comply with those requirements if an employer either doesn't comply or hasn't worked with the department on getting them into place. But it is something that we check and that we screen for.
Thank you.
Thank you. Any further questions for the department? Thank you.
Thank you. You're welcome.
Mr. O'Connor? You please.
I might as well. I wasn't necessarily going to talk, but I had heard some discussion, and this is the first I've heard of it, of switching indemnity calculation from gross to net and going from 60 to 66. So because this is the first I'm hearing of it, I don't have chapter and verse to give you, but I can tell you, I'm not aware of any state that does it that way. As far as I know, every state bases it on the gross earnings. And I think the reason for that is that it's simpler and fairer, in that if you try to do it by the net, you're looking at different outcomes for identically situated employees. Meaning you got two employees making $60,000 a year. One employee has to take the health insurance for the entire family and pays a higher tax rate because his wife is doing really well and contributes max to his 401k. And so his net is going to be much smaller than the same person who can take the family health insurance through a spouse and doesn't have any kids and is paying less in tax. So their indemnity rate, that's based on the net, is going to be wildly different. So I think that could present a problem. It's an equal protection problem. So I just wanted to float that out there and see if you had any other questions I could answer. I wanted to at least mention, I forget exactly the context of the question, regarding during COVID and the kinds of cases that we saw, because I can tell you, for those who don't know, I represent injured workers exclusively. That's been my practice for 20 years. And so I can tell you that with the advent of remote work, which obviously exploded during COVID and is still lingering in large degree, I think we didn't see, or I didn't see, a significant increase in claims or even much of a change in claims, because the kinds of work that is amenable to remote work is office work. And you're not going to get major injuries in office work anyway. So you didn't have a ton of injuries when they were in the office, and now they're working at home doing the same thing. And you similarly don't have a lot of injuries. During COVID, the kind of injuries that we saw were from police, fire, trash, pickup, people that were out in the community doing physical work, Amazon delivery drivers. Like that is what we saw during COVID. So I don't know if that answers the question or helps put some context to it, but.
Representative McKenzie.
So I'm interested in whether or not people actually filing claims that are remote workers. So how often do you see people fall down? If you're working, you fall down,
Right.
so this is a whole new world we're in.
Sure. And it's funny, I've described it when I've given, continuing legal education seminars as potentially the cutting edge of workers' comp, those kinds of questions. But as a practical matter, I don't think I've seen it yet. I can certainly imagine that kind of claim. Someone's working at home and then they go and get a cup of coffee downstairs. Are they in the course of their employment while they're doing that? You can imagine those kinds of issues coming up, but I haven't seen it personally once. I haven't had a case like that. So, not to say they don't exist, but it's not something that I've seen at all yet.
Any questions?
Any other questions? Okay,
Thank you.
sure.
Anybody else want to speak on this topic? I think we've heard from everybody. Then we'll move on to a discussion on unemployment insurance. Mr. Lavers? How are you?
Waiting for everyone to get up and leave.
Not everybody. A couple of them are going to stay. So I want to set the stage. The last few years, we've seen a number of bills for raising the reimbursement rates. And I'd like to actually ask you how we should get it done. If you want to raise something, to actually hear from the department, how the department would like to see it done, instead of being handed a bill and having to do all of the actuarial work, all of the indemnity work, all of the work, and then we make a little change, and then you have to go and do it all over again. If there was something that we could have, okay, boom, 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 this is what we're looking at, how would the department do it? And that's why I asked you to be here today. It's a different approach.
Okay, so Rich Lavers, Deputy Commissioner with Employment Security. Thank you. So if the legislature were interested in changing the statute on weekly unemployment benefits, what your question is, how would the department go about determining what that change will be?
How it would fit within your systems, how it would make, maybe reduce some of the regulations, maybe reduce, how do we make it easier for you to implement it without having to go through, 5 different bills we all put in, want to do it a different way, and you and that other gentleman have to do all the actuarial work for us.
Okay. So I think the mechanics of, in terms of implementation of a change, as long as a change maintains the same type of calculation as we do now, where we look at the individual's earnings in covered employment during their base period. We have 2 different types of base periods. One is the first 4 completed quarters of the last 5, and if you don't have sufficient earnings in that, we look at the most recent completed 4 in that last 5 to make sure that we're getting an accurate amount of earnings that we're going to provide some wage replacement for. So as long as we're looking at base period earnings in covered employment, and then we're tying that to a weekly benefit amount, that is the easiest for the department to implement. Requires very little change to the system itself and how those weekly benefits are calculated. If we get out to making that a percentage and needing the
system to actually calculate that benefit differently or calculate a unique amount for each individual, that would be harder to implement. On the forecasting side, with a lot of the interaction that we have when Brian Gottlob, the director of the Labor Market Information Bureau, and I come in and talk about the known and the unknown. I'll turn this way for a little while. The unknown and the known impacts of the proposals that we've seen over the years. What you see from us and what we think is the most responsible way to do this is that we provide both some of the data points that would lend a person to think, oh, why haven't we touched these in so long? It's long overdue. And then also look at the impact on the payers into the system, the employers, and what is the cost to employers to implement a higher weekly benefit amount. So we try to bring that balanced approach in the information that we bring. We also stress test the trust fund when we do that, because while we don't know when, we know that we will at some point be confronted with another economic downturn. We don't know what the severity of that will be, but any economist, any labor market economist will tell you that they build a baseline of 15% into their forecast, 15% chance of recession into every year. Because on average, we experience one every 7 years or so. So we bring that in a stress test type model. What you've seen from us, for instance, with the most recent bill from Representative McKenzie, when we applied his amended weekly benefit schedule to our current benefit volume, claim volume, right now, not much change, right? You didn't see any additional cost to employers. Employers' rates stayed largely the same. The forecasted reductions to employer rates that are triggered off of the balance in the trust fund, those stayed about the same as if you didn't make a change. But it was when we looked at the stress test scenarios, so looking at a mild and then a more significant downturn, that we saw some difference that translates into additional employer cost. So forecasted, not real, but forecasted. And that's where we saw employers losing their fund balance reduction or their discount on their experience rate sooner than if we hadn't made a change. And in that scenario, the change was insignificant and significant at the same time. It was insignificant in that the employers lost their forecasted fund balance reduction, so an increase in their rate just one single quarter earlier than if you hadn't made a change. So that was fairly insignificant. The significant part was that you lost it in the first quarter of the calendar year, which is most employers' most expensive quarter for purposes of unemployment compensation tax. And so that's why you saw that price tag for the loss of that fund balance reduction a quarter sooner than if no change had been made. You saw that price tag about $20 million statewide for employers, and that was an additional unemployment compensation taxes that all employers would be paying as a result of that forecasted impact on that change. So that work needs to get done regardless of what the proposal is. Where we get into probably a higher amount of work and a little bit more of or a little bit less certainty into the information that we provide is when you start changing the mechanics of how we're going to calculate either the experience-based rate for the employer, how we're going to calculate the reductions in their rates based upon the solvency of the trust fund, and then if we're going to change the mechanism for how that weekly benefit amount is calculated from how we do it right now, based upon if you have at least this amount in base period earnings, you're going to get this amount in benefits, to some sort of percentage calculation. So you bring in all those variables, then the level of work that we need to do goes up significantly, and it becomes less reliable because now we're looking at a lot of different unknowns or changes from what we currently have. But I would say the information that we bring you now, the impact on the current status quo economy is rock solid. Where our confidence level goes off a little bit, obviously, is in the forecasted recessionary. So we don't know when they're going to hit, and we don't know the severity of them. We just can tell you, based upon prior New Hampshire experience, this is what a modest recession did before. This is what it would happen if you did that now. Same with a significant recession. I don't know if any of that answers your question.
It did, at least for me. It put me on a path to my next set of questions for you. Any questions on Representative Sullivan?
I'm just looking at the handout that you gave during the hearing, and I just wanted to look at the urgency of doing something. One of the pages you've got here shows the wage replacement rate going from 50% in 2007 down to about 29% now, a drop of 21%. I'm not going to ask you if you would agree that it's urgent to do something different, because you won't answer that. But I guess I'm saying to my colleagues, it's urgent. And Mr. Labors has provided us with the data and statistics to show how urgent it is. We need to find a way to start making some change. And I'm not going to say we screwed up, because I don't think any of us were around. But basically, the legislature screwed up in letting this sit for so long and not doing anything about it. And now, it's a very dramatic hole that we have to fill. So with that, I will just carry on with your questions.
If we did a full 50% back to a full 50%, and we raised the maximum to 50,000, would that harm your system to the point where you would need to upgrade? I'm just looking to work within your what you have currently, or if we need to fund some type of upgrades to your systems and stuff like that.
So let me make sure I'm understanding that correctly. So right now, if an individual has at least $41,500 in their base period earnings, they receive $427 a week. So that person that's making 41.5 is getting 427. That person making 60, 80, 100, or $1 million is getting 427. With your reference to a percentage, you're talking about it just being a straight, say, 50% of their base period, or their weekly average of their base period earnings.
Right.
So that would be a different way of calculating it than we have right now, because right now it's the statutory table, and so you fall into one of those rows. Majority of people fall into the highest level because that the base period earnings amount is so low compared to what the average private sector worker is earning. So if you went with a straight percentage, it would have, obviously it would have a significant impact on the overall amount of benefits that are going out. And yes, the change would that would be necessitated to be made to the unemployment system itself, the IT system, would be more significant. Certainly doable. It would come with costs. It would be a longer period of time. When you make changes just to the amounts, like increasing the tiers, like we're looking at with Representative McKenzie's bill, that was something that the department would have done. If you had told us we need to have it done in 30 days, it would have been done in 30 days. Very easy to do because we have an existing vendor that solely supports the New Hampshire unemployment system. That another way of calculating it we're looking at a longer period of time. So you're probably looking at a 6-month project in order to change that calculation method. And there would be cost associated with that. So
So is it easier to stick with what we've done in the past of the tiers to stay within your current system? Or is it time for, it's been 20 years, is it time to bring us into something more realistic?
I think the current system, the fundamentals of the current system, I think work. I don't think that's the the issue. I think it's that those amounts have stayed static for, as long as they have since the legislature introduced the additional 4 tiers that were put in back in 2007. So when you do that and you have no mechanism for increasing those amounts, and inflation does what inflation has done over that time period of go up 30 some odd %, purchasing power, wage replacement rate, all of that go down significantly to what Representative Sullivan had mentioned. 2007, the legislature had set those additional tiers. When you looked at what the private sector worker was earning, that was on average about a 50% wage replacement rate. Now that same average private sector worker is looking at a 27, 28% wage replacement rate because the tier itself hasn't been touched. And so if you kept that existing model, put in an additional 6 tiers, 12 tiers, whatever you want to do, that could help alleviate the drastic reduction in the wage replacement rate of the current amount of benefits. But again, we do that with, it will obviously have an additional cost to the trust fund.
Representative LeBrie.
Nationally, I don't know if you can go nationally with us here, but where does New Hampshire fall with 427 compared to max benefits paid out nationally? Are we in the very lower tier here? Are we average, or where do we live?
We're well below the national average, and somewhere buried in the handout that I see Representative Sullivan has, I did include a state-by-state breakdown when we last talked about this. So New Hampshire right now, we are at the bottom for the maximum weekly benefit amount. The maximum is 427. On average, we're at about 360 a week. Both of those are towards the bottom for all of the states in the Northeast. Nationally, that puts us down somewhere in the, I would say, bottom 16 states or so, but certainly the low within our region.
Follow up?
Please.
And if we could we draw a correlation with unemployment claims? Where does that intersect, if you
Yeah,
would?
so it's a good point, because there's obviously, anytime you increase the wage replacement rate, any economist looking at that and asked to project out what will happen to the system with an increase in unemployment benefits will increase the average duration as a result of that, right? That's just a natural thing to follow. The existence of unemployment benefits, just the existence of the benefit increases the duration of unemployment, intentionally so, in some degree. So right now, New Hampshire is at a little over an average duration of a little over 12 weeks. Most groups, when I'm out talking to them about that, and I ask them what they think is the average duration based upon what they hear out there, if I tell them that people have 26 weeks available to them, and then when I tell them the average duration is about 12, they're usually surprised by that. They think it's going to be higher. Average duration in Massachusetts is about 18 right now. Certainly not a model we want to follow, an insolvent trust fund, all sorts of problems. Right now, rates on employers that are triple what New Hampshire employers have and about to get higher. but they have an exceptionally high weekly benefit amount, one of the highest in the country. And they're at 18 weeks. New Hampshire is at 12. So our average duration is one of the lowest in the country.
Well, in Massachusetts, not to harp on Massachusetts, but if the unemployment rate is high and the span is long, I was not great in math, but could you speak to that?
Yeah, so the problem, what you want to avoid, right, is a wage replacement rate that gets too close to being full compensation amount compared to what you are earning prior to being unemployed, because that lowers the incentive to get back to work. We saw that during the pandemic. We had the federal government came in, provided an additional $600 a week for a large chunk of our workforce, for folks that for a period of time were not able to work during the pandemic. They were receiving more in unemployment benefits with that federal enhancement than they would have had they remained at work. That made it very difficult for people like Mike Summers and the Lodging and Restaurant Association, that when we got back to a point where we were ready for people to go back to work, to get them to go back to work, the state actually had to end the federal pandemic programs earlier than all of our surrounding states, in order to get that to be kind of right-sized and to have people have the proper incentive to go back to regular employment. We ended those programs in June of 21. Other states kept on going until September of 21, but then Governor Sununu ended them intentionally early to try to get people back to work during that busy tourist season in that summer. So that's, it's an example of when you increase the amount of benefits, the wage replacement rate by too much, you're getting into creating a disincentive to return to work, and your average duration goes up, right, for how long people are going to file. Certainly not the case in New Hampshire right now, with the average duration being less than the amount of weeks that people have, less than half of the amount of weeks that people have for them. But certainly one could say that on average, a private sector worker getting wage replacement of under 30% for what they were earning, not enough to sustain them through a period of unemployment either. So, when we set that, when we set it in 2007, you were looking at about a 50% wage replacement rate for that average private sector worker, and that's fallen significantly.
And last follow-up, if I could.
1 second. Representative Sullivan.
You were just saying that you'd want to make sure that, excuse me, love spring. That you don't want to let your compensation level get too close to full compensation. Do either of either the 12 tier extension or the 6-tier extension that Representative McKenzie proposed, do either of them get anywhere near being too close to full compensation?
I would say no. I think when we looked at the amended proposal from Representative McKenzie, which had fewer tiers being added to the top, you were still compensating that individual that was earning, say, $60,000 or between $60,000 and $65,000 gross. That person was being compensated at about a 55% rate. So, 54% of, they were getting 54% in unemployment of what they had earned in their covered employment. So I don't think at that rate, I don't think you're creating, you're not making it enticing for an individual to stay on unemployment for longer than they need to find an appropriate and suitable new job. But again, it is higher than what we're currently paying, so there is cost associated with that, and that's what you saw from our scenarios that we ran of potential costs for employers who fund 100% of the system.
Representative LeBrie, your follow-up.
So if we had to select a percentage number and just say it was, say somebody made $100,000 and the system paid out $50,000, what would the exact percentage be where it became not something that they wouldn't look forward to staying on unemployment? What would be that percentage? So I'm sure this has been sliced and diced 1,000 different ways. And I'm just trying to figure out exactly what percentage is it that all of a sudden I'm receiving that I'm not interested in staying on this anymore. I need to move. I need to get a real job here. So is that, could you lay down an actual number?
Well, I think traditionally, and looking at what people and how most states approach this is somewhere in that 60% range, not higher, right? So that you're compensating, you're providing enough of a financial bridge for someone in their family who's unemployed through no fault of their own. So again, this is, not a situation where someone did something that caused them to lose their employment. It's, they're laid off, some other situation that they've lost that job. They're hungry to get back to work. And traditionally, you're looking at nothing, you don't want a wage replacement rate that's higher than that 60%. Traditionally, in New Hampshire, we've had that wage replacement rate of 60% at the lower end of that table. So those lower wage earners are at around 60%, and then it gradually reduces back to the low 50s as you get to the higher end of the table. And that was largely what the amended proposal from Representative McKenzie did, but again, with additional tiers. So he maintained that same wage replacement at the low wage earner part of the table, and the higher end part of that table for people that were earning $65,000. That wage replacement rate was 54%, which is exactly what it is right now if you're a person earning 41.5. But as we saw in some of the data that we brought in, the people that are coming in qualifying for the 41.5 right now are not earning 41.5, right? They're earning, I believe we had looked and they were earning somewhere on average around $78,000, $80,000.
Representative McKenzie.
Thank you. Thank you, Commissioner. Good to see you again. So I wonder if you could speak to what was raised about the higher the unemployment benefit is, the longer people stay out. And I ask you to respond in the context of the requirement that people have to be available and looking for work. That does not disappear. So correct?
Correct.
So that's
Correct.
always there. Can you, if I could, is it a possibility that people are taking advantage of the services that you offer through the department and potentially are in a position to transition to different careers, which the department does all the time, correct? To train people for different things. So does a little bit more benefits, a couple more weeks, give them a greater opportunity to transition, perhaps?
You're correct. None of the requirements that we have on everyone, for the most part, everyone that is collecting, that qualifies and is collecting unemployment, you have to demonstrate on a weekly basis. So this is not just something that we take an application at the beginning of your claim and then say, hey, we'll see you in a year, like other types of government benefit programs. You have to come in every single week and demonstrate your eligibility. You have to demonstrate that you are able to work, you are available to work, and that you are conducting an adequate and suitable work search each and every week. And at the beginning of a claim, some of those things that might be adequate are I'm working on my resume, I'm doing some work to polish up my network of contacts, And then as you get later on in that claim, say past week 4, we want to see actual contacts with actual hiring employers. And so that requirement doesn't go away. That requirement, unless the legislature changes that, those requirements are all stay. We evaluate that again on a weekly basis and make sure that that is happening with each and every claim. Now, we don't have a counselor able to sit down with all 3,000 people that are currently filing each and every week and go through with a fine tooth comb on, okay, I see that you had applied for a job at Walmart. Now tell me, how many days has it been since you did that? And following up and pressing them on that job necessarily. In some cases we do, because they're required to come in and have mandatory meetings with us. But there can be, in some instances, the quality of that job search can be less than what you and I might want, and we're always trying to increase that quality. But none of the requirements for eligibility, unless they were changed by the legislature, we would continue to implement them as best we can and make sure that people are certifying and demonstrating all of those elements with each week.
Representative Sullivan?
Yeah, I wanted to respond to something from Representative Labrie. You painted a scenario where a $100,000 wage earner would get 50% replacement for $50,000. And I just wanted to make sure that we all recognize that the two bills that were presented, neither of them went to $100,000. And so essentially that $100,000 employee would not get $50,000 under either of these, either the original bill or the amended bill. They'd get dramatically less because basically there's a ceiling. And I think that that's the hazard with choosing a percentage. I mean, at one point, Mr. Lavers indicated that, it doesn't matter if you're making $1 million, you get no more than the maximum weekly benefit. If we set a percentage and we said, doesn't matter what you earn, then the $1 million employee would be getting $500,000. So the advantage of addressing it in the manner that Representative McKenzie has is that right now we've got a ceiling. I think we're suggesting, perhaps we're recognizing the ceiling is too low. But the methodology here sets a new ceiling that might still not be, in some people's view, high enough, but it basically sets it higher so that more employees who are on unemployment are not taking such a dramatic hit, going down to 29% of earnings, which if you're accustomed to living on $60,000, getting 29% of $60,000 is quite a hit. And, someone earning $60,000 has got a different mortgage than somebody earning $40,000. And their ability to survive at a base level is much more difficult under the current system, which is why I believe we need to do something.
Representative Labrie?
One of the points I wanted to make earlier is it feels like sometimes when you speak to somebody who might be out on unemployment, whether it's Massachusetts or New Hampshire, that when they have to go in and they have to present where they've been or where they've searched for a job, there's like sometimes a connotation that the system can be gamed, or you don't have a staffer to meet with those 3,000 people. So how do you tighten that up? Because I feel like we need to tighten that up before we went any further with any of this. Because if I can come in and just tell you, I went to McDonald's, I went to Burger King, I went to Wendy's. That's it, give me the check. That dog don't hunt. So I would kick this back onto you guys and say, do you even have enough employees to handle this? And by saying that, if you have 3,000 people on unemployment and you can't meet with them all, how do you do this?
So it's a good question. We'll never be funded at a point where we could sit down with each and every individual that's filing and walk them through that work search for that week. So the the experience of every individual right now, every individual has to come in at the beginning, right? Everybody comes in for a group workshop to learn the mechanics of filing, to learn the requirements of what it means to be able to work, available to work, conducting an adequate work search, how you go about reporting part-time earnings, how much you're allowed to earn, answer all of those questions. And if you don't come in and you don't make your workshop, you're in pay held. You're not getting benefits. So that's how we create that incentive to come in. Now, for a portion of filers, they also have to participate in a program where they come in 3 times over the course of their claim and meet one-on-one with staff, and they go through and they create an individualized employment plan, and then they try to meet with them and help them achieving the goals in that individual employment plan as they go. But again, not everybody. Everybody has to tell us what they're doing. Okay, they have certain types of job search related activities that they're able to certify to having conducted. Those activities change depending on how long you've been filing. So again, someone can't come in and tell me that they've worked on their resume for 26 weeks in a row and it be qualifying to help them achieve an adequate work search. You can come in and do that for the first 4 weeks, but on week 5, that item disappears from your weekly claim. It's no longer something that you can check off and say, hey, this is one of the activities I did. Now just leave me alone so I can continue to get my benefit check. It's not something you can claim and get credit for. You tell us the employers with whom you've interacted, when you interacted, how and why. Was it inquiring about a job opportunity? Was it applying to a job posting? How did you apply? Who did you submit the resume to? When did you submit the resume and application to that employer? So that all that has to be provided right now. Some additional tools that we're looking to bring in to that process, acknowledging that the actual number of full-time employees will never be adequate. We won't get the federal funding to support that, and we're not going to request that level of funding from employer quarterly taxes to be able to fund that level of staffing. So what we're looking at doing is building in some additional ability within the system that where the system is following up on your actual activities. Okay, not doing it in a generic way, but doing it with some AI tools that can look at what you have done, what you've told us you've done, what we know is available within the sector within which you've lost employment, and making specific inquiries about your efforts. And I think that will go, it will be a higher level of quality in terms of how we're interacting with those customers. I'm not suggesting that we're doing that because we think that there's all of this fraud, waste, and abuse throughout the system. I think that by better interacting with those customers, we can increase their awareness for real opportunity. And I think, and I approach it this way, that they really want those opportunities. And those people that aren't taking advantage of those opportunities, will be holding them accountable, and it will impact the payable status of their claim. So we're looking at bringing some better tools so that not every filer has to have a high level of sophistication in terms of how they go about conducting a job search. We can do a lot of that for them, right? We know enough about each and every customer where we can be doing more of helping them navigate that job search, navigate the employers that are hiring, navigate the training opportunities that they have if they're looking to have a vocational change. We can be doing a lot more with technology than we're currently doing. And we have plans to do that. So timing for all of that, we're about to bring the whole unemployment system onto the cloud. We start that. Right now, it's on premise here in Concord. I manage a data center. I'm a lawyer by training. I shouldn't be managing a data center. We'll be bringing that to the cloud starting in May. That will be completed in December is the goal right now. Once that is completed, we're then going to implement some modernization projects. All of this is being funded by the federal government with a grant that New Hampshire received last year, where we're going to be bringing in some AI tools that are going to help improve that customer experience over the entire life cycle of a claim. From the moment you come in terms of how we get information from you to talk about your job separation, no more drop-down menus and predetermined questions. You're going to come in and we're just going to say, hey, what happened? And then based upon your response in real time, we're going to ask questions that are personalized to your experience and get much better information. Then throughout your claim, we're going to bring that same level of personalization through AI tools that will then be disclosed to you, be fully transparent to you, but will assist you with getting that better personalized experience with better job opportunities and things of that nature to hopefully reduce the duration of your claim, but certainly provide you with a better quality experience and a better employment opportunity than perhaps you're finding now because you just aren't able to navigate the system and all of the different tools that are available to you. So over the course of the next year, all of that is going into place. So by this time next year, all of those tools will be in place.
Follow up. Just more of a statement. I feel like the trust but verify system that you have in place now doesn't set well with employers. If you had something in place like you just spoke of that's coming online in a year, and I'd like to know how that's implemented and where that all lands. Is that something you guys have already budgeted? Is that something in the AI that's already written down, ready to go?
Yeah, so it was New Hampshire was one of 18 states that received a $11.25 million grant from U.S. Department of Labor to help states modernize their unemployment systems. We're using a portion of that for moving the system to the cloud, take advantage of a lot of performance improvements that we can get through being on the cloud rather than being on a bunch of hardware sitting in our data center here in Concord, and through the AI modernization and bringing those types of tools to our customers, all budgeted, all federal dollars that we're utilizing, all obligated. Made sure we had to obligate it so that none of the dollars were taken back by the feds. So that's all something that's happening over, like I said, that's over the course of the next 12 months. So by May of 2026, all of that will be implemented.
That's good to hear. I just, if you guys can bring some integrity to this piece of it, I think we're going to have a much more fruitful conversation down the road.
You know, one thing I would add, and I hear your concern with regard to the integrity piece and employers and their perceptions of how much integrity is within the unemployment system. One thing that does occur quite frequently is, and I hear this from a lot of employers, anytime that they have an individual who's less than cooperative with applying for a job, or they don't show up to an interview, they always assume that that individual is filing for unemployment benefits and is simply contacting the employer and setting up an interview just to appease employment security so that they can continue to get those benefits. And that, I'm sure that does happen, but what we do find in most instances is that the person that isn't being cooperative or isn't showing up for an interview, they're not filing for unemployment benefits. There might be something else going on. I don't know if it's another type of assistance that they're getting, but in all of those situations, we then, the employer reports that to us because we encourage employers anytime that they have that type of experience, we want to hear about it. In most instances, it's not someone who's currently filing for unemployment.
Representative McKenzie has one. Yep, go ahead.
Thank you. If somebody steps out of line in the employment security process, my understanding is there is a pretty robust legal system within the department that takes them to task. So if they were not doing what they said, filing false reports, all of those kinds of things, there is a whole mechanism to take them to task, correct?
Well, anytime we obtain information that shows that you're not eligible, so you're something that demonstrates to us you're not able to work, you're not available for work, say that we find information that you've been on vacation for 3 weeks, right? Or a week, and you've been filing, and the vacation has nothing to do with your job search. Those individuals, they are ineligible, and they receive a determination from us telling them that. And we have all sorts of ways that we detect it. Obviously, people slipping up and telling us about it inadvertently, but we also look at your IP address from where you're filing. We look at other types of situations that alert us to a problem with your claim. And same with what you're putting down on your efforts each week to find new employment. We're looking at that. We're told about problems, but we routinely detect issues. Those issues result in determinations finding people ineligible, and then there's a multi-layered appeal process for individuals to go through, just like you have at the beginning of your claim. If you disagree with the initial determination that says you're ineligible, or the employer disagrees with the determination finding them eligible, all of those are appealable. You go through multiple levels of administrative appeal in the department, and ultimately you can end up at the New Hampshire Supreme Court. Very few cases get there, but we do about 225 hearings a month on individuals that are either the employer or the individual disagree with a determination that they've received, and we go through it and determine, okay, are they eligible or are they not eligible?
How much is in the trust fund currently?
The trust fund is at about 386 right now, forecasted to stay within that 370 to 395 range over the course of the remainder of this year and the next calendar year. It's not forecasted to hit the $400 million level, which is the statutorily set threshold for that maximum fund balance reduction for employers of 1.5%. But it's not forecasted to fall below the current threshold for the 1% reduction they currently get, which is $350 million. So we're actually at a point right now, even with a very low amount of claim volume. We're lower than we were in 2019 prior to the pandemic. So even with we have a low volume environment, and employers are at about a 30-year low in terms of the average tax rate for private sector employers, where we're actually paying out a little bit more than we're taking in right now. And I think that's just, and that's a reflection of how low we are for the tax rates, where we've been historically, and that just results in a trust fund that kind of just sits in that tight window that we're at. But historically, that's the highest we've ever been. When we entered the pandemic, we were at 300 million, and now we're close to $100 million above that. So we're solvent. That's not just me telling you that. That's the U.S. Department of Labor. They do their annual solvency analysis. They have us a slight hair below solvent, but their metric, we were solvent at 300 million, and yet at some point, some reason at 386 million were not solvent. The reason is because they haven't adjusted their tool. Their tool, in order to determine solvency, looks at your 3 worst benefit payout years in the last 20. The pandemic is one of those, right? I don't think any economist is expecting that level of unemployment to result from any type of problem impacting the labor market anytime soon. They still factor that in. But, trust fund is solvent right now, forecasted to continue to be solvent. We didn't borrow during the pandemic. We don't have any reason to believe with any recession that we could get hit by, we have no reason to believe that we would need to borrow.
Last follow-up?
The average, the employer pays on the first $14,000. What is the average cost per employee for unemployment in New Hampshire?
Right. So taxable wage base at $14,000 amount. At average employer right now is paying about $85 per year per employee.
Thank you.
Representative LeBray.
If I was unemployed and I was, I needed to get my check, do you have an ACH option? And if you do, why?
You're talking direct deposit. So we have it right now. When you come in, when an individual comes in and files their claim, they're able to make it's their preference whether or not they're going to receive a paper check or they're going to receive a direct deposit. About 85% of individuals elect for that direct deposit. We don't do debit cards or any other types of mechanism for accessing your unemployment benefit. So you do have that option for a paper check. Very few people elect that. And the direct deposit, we have several layers of control in place for that with fraud detection methods that we have, including that if someone comes in and then a claim gets hijacked and that imposter tries to change the depositing institution, there's a lock that goes in on that claim, and then it gets investigated by a real human being to determine that that was a legitimate change. So we have several controls in place to make sure that whatever the depositing institution, whatever it is, it's the actual individual who has verified their identity using login.gov prior to ever being paid benefits.
Cybersecurity, good to know. Wasn't my point. My point is, if I had to come to you and get a paper check every week, that would get old real fast. And I would be embarrassed, motivated, driven to get a job. I think ACH is doing you and the state a disservice. And years ago, we didn't have this option before technology. If you're asking me for my opinion and you didn't, I would travel back in time and eliminate ACH. And I think you'd find even less people on unemployment.
Well, I've been with the department 15 years. The direct deposit predates my time with the department by a significant number of years. I'm not sure exactly what that is. I don't know of, and I haven't looked at this, but I don't know of another state in the country that doesn't have some sort of direct deposit option for people to file their claims. You have to come in to the office right now at the beginning of your claim, and then for a subset of claimants, you have to come in periodically. I think there's a reason why anonymity is brought into the unemployment system, right? Because it's embarrassing to lose your job. It's embarrassing for you to have to tell your family that, for you to have to cut back on everything else. It's embarrassing for your neighbors to see you not leaving to go to your job. Then you got to talk to them about it. I think there's enough embarrassment, enough in losing your job, just from my own experience, that I don't think we need to build in other accountability mechanisms that lessen the convenience of being able to access those benefits. You got to come in every week. You got to file a weekly claim. You got to certify to us. You got to conduct your job search. You got to be doing all of those activities And right now, if you're the average private sector worker, you're getting about 29% wage replacement. I'm not staying on that very long because I can't afford to without losing everything in my life. So I think there's a good amount of convenience that's provided with direct deposit, and I don't know another state in the country that's retracted from doing that.
Representative McKenzie.
You have, what, is it 8 offices, 9 offices throughout the state? How many offices?
We have 12 offices that are full-time and then two offices that we consider itinerant. They have just a fewer numbers of staff. So Colebrook has a smaller staff. There's a 1.5 FTEs in Colebrook. And then we have a person that goes to Plymouth 1 day a week and uses the United Way facility to meet with people that it's more convenient there. But we have permanent offices: Berlin, Conway, Littleton, Laconia, Concord, Keene, Claremont, Salem, Manchester, Nashua, Portsmouth, Somersworth.
So you don't have them in every city, so people have gotta find the office and get there after they lose their job. So, it's not as easy as you might think. Some people, they lose their job, they get knocked off pretty easy, and they lose a lot of stuff at the same time. So we don't have offices in every city to get there, to pick up checks, but I think it'd be difficult for a lot of people, overall. Let me just ask you one final question, if I could. The unemployment, when you lose a job in something that's not a demand occupation, and you have some skills, and you'd like to go into a demand occupation, the unemployment office has the capacity to help you make that transition, correct?
Correct. Yeah, the focus of the work that's done in all of those New Hampshire Works offices is reemployment and training. So, through both employment security, but business and economic affairs, Southern New Hampshire services, other CAPs throughout the state, we implement all of the training assistance programs. So, we'll pay up to $6,500 in most instances for you to pursue training in a high demand occupation. As long as you're meeting the requirements of that program while you're in training, in some instances, your work search requirements are waived. And so we do that right now through an assortment of programs. People that are in the unemployment program qualify for Workforce Innovation Opportunity Act funding through the federal government. People that are not in the workforce that want to come in and get trained to be in the workforce in a voluntary capacity. So people in Medicaid expansion, TANF, SNAP, all of those individuals can come in and utilize a variation of that program where we'll pay for a portion of their training. We'll pay an employer to hire that individual. We'll support them with transportation, again, in order to help grow the labor force, get these folks beyond a barrier, get them working. That's all voluntary, but there's an assortment of training programs, and those 12 offices, that's their focus. That's what they do.
So you,
Follow?
thank you. So what you've been able to do is that as some occupations kind of die off, like shoes and textile and all these paper and all those things, that you try to stay ahead of it. So you try to come up with programs that support the new economy in New Hampshire. Is that correct to say?
Correct. We try to encourage people into the high demand occupations, but don't let the New Balance people tell you that shoes are not cutting edge. If you've gotten an opportunity to drive by their new facility in Londonderry on the way to the
Well, no
airport,
kidding, I know.
shoes are definitely cutting edge, particularly for an employer that makes, for a shoe manufacturer who makes their entire product in North America. And a lot of that coming to New Hampshire right now. Not a commercial for them, but it's pretty impressive what they're doing down there.
Any further questions for Mr. Lavers? Representative Drago.
Circling back to the very beginning of your talking to us, it sounds like having a table is a much easier way to implement something than the 50% straight up like that, just for software purposes or whatever. I was reminded,
And cost as well.
and cost, yeah. last year, I think it was last year, we had a bill that basically allowed you to earn some money in conjunction with the unemployment. It kind of fluctuated back and forth. Would that fall in the 50% category where it's harder to implement and it would take more, software or computer stuff, or would that fall into the table that we have? How would that work?
So right now, and there was a bill, you're right, last session or last year, that would have looked to change what we refer to as the part-time earnings disregard. So New Hampshire law allows an individual to have part-time work. So in order to get to that point, you have to have a qualifying separation from employment, right? So you might have had full-time and part-time and you lost your full-time, or you might find the part-time after you have that qualifying separation and you're collecting unemployment benefits. So we allow you to have part-time work. So you can't be working full-time. If you're working full-time, that's a disqualifier from unemployment. I say that with somewhat of a smirk because I thought that was obvious. And then I talked to some people and it's not. So you can't be working full-time and collect unemployment, right? So you're allowed to have part-time hours and part-time earnings. And New Hampshire, like every other state in the country, has some type of disregard for how much earnings you are allowed to have from part-time work without it impacting your unemployment benefit. So right now we have a 30% disregard. So you are allowed to earn 30% of your weekly unemployment benefit, the equivalent of that, before it reduces your weekly unemployment benefit. Every dollar earned above that 30% is a direct reduction dollar for dollar to your unemployment benefit. So New Hampshire functions as a percentage, and I think the effort was to change that percentage. Other states do it as a flat dollar amount. I believe Maine sets it at $100. So you're allowed to earn $100, and anything above that will then reduce your weekly unemployment benefit. But New Hampshire has a 30% disregard, and it has to be part-time employment.
Good, Representative.
Okay, so but the 30%, assuming we just made it 40%, that would still, that seems like an easy switch for you guys. So that would probably fall under what you had said earlier. If you guys implemented this tomorrow, it would take you guys 30 days, or if we went to 50%, it would take you 60 days. So if just by increasing the percentage, that's probably on the easier fix side of things.
Yeah, that would be, pretty straightforward. The only thing that would take a little, the software side of it would take, they could have it done before I got back to the office. The actual training part of it would just, take a few weeks to get staff up to speed on conducting the new calculation when they're verifying those folks that are reporting that.
Okay. Now that we've nibbled all around the edges, through the good times, if we did something that was at, let's say, without getting into, if we had a $600 cap and we did a 50% wage replacement up to 60,000, which would be roughly $600. If we did a 50% replacement in the first 10 weeks and then a 40% replacement in the next 10 weeks, and we lowered the amount of weeks in the good times because people aren't they aren't going out as far. That way we could build up their trust fund so people don't fall into the negative going into a huge recession. And if we took something, and if it goes above 5%, we would adjust that accordingly. We would go back out, the 50% for the first 13 weeks and then 40% for the remaining 13 weeks. It gets it gets us to where we are, gets us above where we are today. And then if we adjusted the triggers to get the trust fund to 450, because I look at it like you do with the big recessions, so we're not falling below having to borrow money from the government, and then possibly an adjustment to those triggers to get us to that 450 threshold in the bad times, and then lowering it back to the 400 million through the good times. Is that something your department can do with your current system?
Before I answer, so what are what metric are we using to determine
Just
the,
state
the,
state
the,
unemployment rate.
so, so the unemployment rate. So the change, so any type of change where you're going to get 50%, 40%, like you're going to tier it down, you're going to stagger it down. That's programming that can be done. That it wouldn't be as easy as just implementing, say, 6 additional tiers of a fixed dollar amount if you got to this amount of earnings in your base period. So that would take a little bit longer, but certainly doable, whether that's a type of 120-day implementation date that you would put into something. That would probably be more what we'd be looking at to have the IT support design it, test it, and then get it to a point of being able to go into production. Whether or not the unemployment rate itself is the best metric, I don't know. There's some concerns around using the unemployment rate in that regard. Like right now, the unemployment rate has gradually gone up. Right, we're now at 3.1%. The number of people filing for unemployment has not. Right, so the demand on the unemployment system to collect benefits for unemployment benefits has not increased at the same time that the unemployment rate has increased, because they're kind of measuring two different things, right? So the people that are filing for unemployment need to have recently lost employment through no fault of their own. People that are considered to be unemployed for the unemployment rate is they cast a wider net for that, right? So the unemployment rate gets calculated by Bureau of Labor Statistics every month. They do a monthly household survey. They start with 1,300 households in the state. They usually get around 65% participation. And they have a designated person in the household, and they ask questions to determine what your status is in terms of employment. So they ask whether you're working. You say yes. That's an easy one for them. There might be some other side questions that they want to know about employer provided benefits, or maybe some other part of the monthly survey that they're doing to get some additional info. But that's easy. You're employed. You're part of the labor force as employed. You answer that question, no. Now there's a whole series of additional questions that they're asking, right? And so the people that get grouped within unemployed, in order to be part of that, you need to be not working, but actively seeking work and have actively sought work in the last 4 weeks, not necessarily filing for unemployment. And I think one statistic that kind of highlights that difference right now is that even though the number of unemployed as a part of that survey has increased from we were at 2.5, 2.6 this time last year, to being at 3.1 right now, the number of good unemployed within that is actually pretty high right now. And by good unemployed, I mean people that are what BLS categorizes as new entrants into the labor market. So they weren't previously working, or re-entrants into the labor market, meaning people that haven't been working for at least 4 months. So that portion of the unemployment rate survey unemployed group is about 56% of the surveyed unemployment right now. So I consider that to be good unemployment. Bad unemployment are job losers, right? Temporary job completers, people that have lost employment. That would be kind of the bad unemployment, because they've involuntarily lost their job and involuntarily are now searching for work. Some of that might spill over into the unemployed or collecting benefits, but the majority of individuals that get categorized as unemployed, at least right now, would not be people that would spill over into the unemployment program and collect benefits, because again, they've been out of the labor market, and for some reason, they're getting back in. Could be confidence in, oh, the sector is doing well. I want I think now is the time to get back into that, or it could be, you need to bring more earnings into your household because of inflation, right? It could be a whole assortment of reasons for that. But it doesn't necessarily translate over perfectly for the unemployment rate to the number of people that are filing for unemployment.
Okay, so what I hear is you want to maybe tie it to an average weekly claim rate number? Goes above, let's say goes above 10,000 of average weekly claimants to 20,000 or something. I mean,
Yeah, like
just-
right now, I think our 4-week moving average is around like 3,600 people that are filing a weekly claim.
Okay, so that would be a better trigger for an in-state, to look at it in-state instead of relying on an out-of-state labor market rate.
Potentially. I mean, it's data that we have and we know and could very easily leverage and wouldn't have any concerns with the data itself. One area of concern that and we've talked about in the past, is, so right now, everyone has eligibility for the 26 weeks, right? And on average, you're using 12. Obviously, when jobs become harder to find and harder to secure because employers are nervous about the state of the economy and they're hiring less, duration goes up.
Right.
Right. And when there's plenty of jobs out there, duration goes down. So it functions, kind of in a free market sort of way, right? Where you got a lot of weeks available, but you're using few because the job market is strong. Job market and the economy can change pretty quickly. And one thing we've talked about in the past is not locking yourself into a fixed number of weeks for too long of a period of time, so that you don't want to be in a situation where the economy goes south, but you're locked into, say, only 12 weeks, but people are exhausting at much higher rates because clearly the 12 weeks isn't enough.
Right.
And you haven't self-corrected yet. Similarly, you don't want to be at a point where unemployment or your metric, the amount of filers has spiked. We're locked into 18, 19 weeks because of the spike, but then it falls off pretty quickly. And now, you kind of got that same type of situation, but the frequency that you're going to be looking to change what's available to kind of to better match up with what the demand is going to be. But right now, again, the way that we have it right now, and the labor market controlling that, it's doing a pretty good job, right? Average duration being about 12,
Right.
being one of the lowest in the country, but 26 is available.
Representative Sullivan.
Just following up on what you just said, it doesn't seem that the system right now needs the type of incentive that what we're talking about, because of all of the incentives to get back to work already. So essentially, tightening the screws on somebody who, and you might tighten the screws at the wrong time, just as you were saying, because the buffering effect. There are, there's a lag time between when things start to improve and when it actually shows up in the data. There's a lag time between when things go to hell and when they show up in the data. And it would create some real inequities for the folks who are unemployed during the period of transition or the buffering period. And I just don't see the need for implementing a system like that when we've got so many incentives in New Hampshire already for getting back to work. And I don't think what we've proposed, and in fact, people at the lower end to have their benefits reduced after a certain number of weeks. It doesn't happen now, and they're still getting back to work within 12 weeks. Um, what we're proposing here is to get people on the higher end um, taken care of in a more equitable way. Um, and it just doesn't, and that person is earning $41,000 will continue to get the same unemployment benefit going forward as they're getting now. That wouldn't change. It's just the people who are earning $50,000 or $60,000 would get a fair amount of income replaced. So I think this would have adverse effects for some people who are presently getting back to work within 12 weeks anyways, at the lower end of the income level, someone earning 20,000. They're already responding well to the system as it's structured. I think changing the structure for those folks is unnecessary and perhaps cruel, because it would be for someone who, for some reason, is going 13, 14, 15 weeks, they're getting a reduced benefit at an income level where they're already getting a pretty small wage replacement. So it is just, and it adds lots of additional complications to the system that I don't think are needed. And I think we might run into some unanticipated consequences that down the road we say, well, we didn't see that coming. So anyways, I don't see that that's a advantageous direction to go.
Representative McKenzie.
If I understand, because I need to get this clear in my mind before asking a question, but you would basically, as the unemployment rate goes down, you would change the benefit. Is that what your proposal is?
No, it would change the length of weeks.
Length of weeks,
Like, we're
okay.
just using 12 weeks, that way the actuarials don't have to go all the way up to 26, they can cut it back to 20.
Okay, all
And the
right,
trust fund
that
would be,
clarifies it. So,
yeah.
in that context, there are people who are in occupations that become really hard to find work. You know, as industries die off in New Hampshire and replaced by whole new industries, it's harder. I mean, when we did the shoe mill up in Berlin, you saw a 55-year-old person that suddenly found themselves unemployed in Berlin, New Hampshire. Thousands of them looking for work. So it's going to take longer for those people to transition those people into the economy, into this new economy. And so that's my concern, that if you look at different sectors of the economy, there are going to be people it's more difficult to do. And they're going to need more time and more training perhaps to get into the business. And I would think that's to the employer's, business advantage, is that you do that job of transitioning them, helping them to transition into the new occupations.
Yeah, and the 12-week average duration is across the board, right? It's not it's all industries, people being separated from employment from all industries, not just manufacturing, not just professional office, it's everything. Obviously there, and I don't know off the top of my head what that average duration is when you break it down by like 2-digit NAICS code, for instance, but.
So what the original take was to bring everybody to 50%, which I'm thinking that everywhere, some of them are, we go back and forth, some of them are at 54%, some of them are at 38% or 40%. When we were looking at the tables, is it all 50% all the way up, or is it some are 49, 48, some are 52? I didn't look through the whole list.
So the table itself, so there's the table, but then there's the actual person, right?
Mhm.
So the table itself with what Representative McKenzie had proposed was I think he was in the sixth, his initial proposal might have been a maximum base period earnings of 65,000, and then he scaled it back to say 60. And the associated weekly benefit amount for that individual earning at exactly that amount was 54%. But if you're earning above that, and this gets to the reality, the real person, right? And this is where the 29% comes in, or somewhere under 30. I can't remember if it's 29 or what it was. But the real wage replacement rate for that individual will be lower if they're earning more
Right.
than what you set as your maximum tier. And so for most people at that maximum tier, their earnings are higher, are much higher than that. So their wage replacement rate falls down below the 54%. And that's where you get, like, right now with that maximum tier being 41,500, the actual wage replacement rate for the average private sector worker who's making around 70,000, that wage replacement rate is 29. But if you're earning right at that amount, it's 54%.
What if we close that gap a little bit? Moving it to 60 at 50%.
Well, you can certainly, by adding additional tiers with higher base period earning amounts, adding those certainly starts to close that gap, right? So again, the person coming in that's making 80, instead of getting that 427, they're going to get, something probably, $100 more than that, or I think it was around that with what Representative McKenzie had proposed. But, you're getting, so by increasing the highest level of base period earnings that get replaced at 54%, you're now doing something more for that person earning 80,000. Because it's really those earners are the ones that are probably having the most difficult time right now with the amount of wage replacement that the unemployment system provides to them. Because the people at the bottom end, that for the bottom third of the current schedule, that's a 60% wage replacement. So they're getting what they were intended to get by the legislature. It's those that are above that, that again, that $80,000 a year person that loses their job unexpectedly, they come in. That person is the one that's getting at that low 30% wage replacement right now. But if you increase the base period earnings to a higher amount than 41.5, then you're addressing that person's situation with giving them a little bit of a higher wage replacement, but not all the way to 54%. It would bring them up to, they'd be brought up into like the 40% range, unless you went way up. Which was not what Representative McKenzie was proposing to do. He was, 60,000, 65,000.
Yep.
The bottom is 60, yeah. But there's very few filers at the bottom.
So if we were to do it at the 60,000 with just a $600 cap, keep it at the 50% replacement wage, and the good times drop it back to 20 weeks, would that help the trust fund and help people to replenish their balance? Without, I'm receptive to Representative Sullivan's question, to concerns, but if it's the good times and we're using 12 weeks, if we cut it back so we're not,
You're cutting it back from 26
to 20
to 20, okay.
on the good times, and
Yep.
we'll find a metric where you're comfortable with that, or the department is, or we all are. It could be at 5,000 weekly claims, it could be 3,500 weekly claims, it could be. And then when it goes up past that number, we go back to 26 weeks to 50%. It would just trigger a weekly change instead of percentages and everything else, because it seems like it's going to be an issue with that.
Yeah, in terms of, we can certainly, because I know you use the word "we" being comfortable, but it's really ultimately you,
Well, I want
right, and the legislature, right?
right.
being
I want
very
it
comfortable.
to be, business side happy, the employee side happy, business owners happy, department happy, political parties happy that we can come together and get something done.
So, yeah, I mean, one thing I think that would be helpful in that, and I don't have it with me right now, and it would have to be, and I'll tell you why you couldn't just use raw data for this, it'd have to be adjusted. But we can look at volume, weekly volume during, say, the Great Recession. Don't use the pandemic. Pandemic is the outlier, right? Stay away from that. But we can use pre-Great Recession, Great Recession, post-Great Recession, pre-pandemic. And you can see, and 2024, and you can see what the weekly volume is during times of the economy starting to go south, going south, recovery, stable. And you can see what that weekly volume is, but we can't just use raw numbers. We're going to have to adjust those numbers for the size of the labor force at the time. Right. Just because 3,000 weekly claims in 2007 is not the equivalent of 3,000 weekly claims in 2025.
Correct.
Because you'd have had a lot of labor force growth during that time period. But we can certainly look at that, and Brian Gottlob and his team can apply a factor that would equalize it across it's apples to apples. But you can see what that volume looks like in those different types of economies.
Yeah, because like you said, if the unemployment rate is not the actual employment rate or unemployment rate for New Hampshire.
Correct.
Representative Sullivan.
I just, with no disrespect, I wonder if why bother comes into it, because essentially if you've got very, very few people who are taking more than 20 weeks of unemployment anyways, would it have any significant impact in going through those contortions of increasing and decreasing the number of weeks? Because clearly the statistics show that there are a few that take the full 26 weeks no matter what the economic conditions are. I would suggest that probably the longer they're out, the more scrutiny they get in terms of their behaviors. But there are also some people who just, because life has treated them poorly, have a real hard time finding replacement employment. And I guess that's why I would suggest that maybe if we don't need to do that to make a significant change, maybe we shouldn't do it just for that small handful of people, 2 or 3 people who have had life throw them some curveballs. That ratcheting up 20 to 26 weeks, it's causing the department to go through some contortions for no real benefit to the fund.
Right, the benefit would be to the employer. So in good times, if they don't have to pay somebody out 20 weeks, they could maintain their positive rating. If they don't exhaust the whole 26 weeks, that would put them into the negative rating, and they would be subject to all of the increases. So if there's something like that, we could, through the good times, of course, to mitigate so they're not paying the penalty phase of being upside down in their unemployment fund.
Those same employers, though, are not experiencing that 26 weeks either on a substantial basis. If they experience it, it's a rarity. So I don't know that it would benefit the employers any more than it would benefit the system.
Do you want to weigh in on that, or?
If you want to see real data, I can give you the number. We've provided what the number of unique individuals that received unemployment during 2023 and 2024 is what we looked at with Representative McKenzie's bill. But I could break that further down to show you the number that are, say, less than 12 weeks, the number that are between 12 to 15, the number that are greater than 15 to 18, the number that are greater than 18 to 22, and the number that are greater than 22 weeks. And so you can see what that breakdown is, if that would be helpful.
Because I presently am making stuff up, so. I mean, my assumption is, based on the 12-week average, that there are very few people above 20. But that's an assumption, and I'd be happy to have that assumption either backed up or not.
That's why that's why we want to have the discussion.
Yeah, sure.
Questions? Gotcha.
Let me just ask.
Yep.
You flush out that data, are you able to do it by sector? So that you can tell us by sector who we have one, you gotta break it down, and the number of claims?
I have all the data. We can break it all down. I mean, I can tell you, you know, an exaggeration, but not. I can tell you how many filers are wearing a button-up shirt, right? I mean, I know their wage history. I know what industry they are coming from. I know what their earnings were, and I know what their experience is with the unemployment system. So we can break down, what I had just proposed would be looking at that duration across the board, how many fall within those categories. And then we could look at that same duration breakdown at each two-digit sector level. So two-digit being manufacturing, construction, professional office, business support, healthcare, right? And you can look across, so you're getting, it's not drilled down to being, oh, I want to know exactly what hospitals experience, because that would be at a sub-level within that healthcare field. And you're not going to know, I want to know exactly what this particular type of manufacturer is experiencing. But the more you break, the more refined you get, the less useful the data is, because you're getting into such small groups. So we could do that same breakdown at the two-digit level. So that'd be a high-level sector level, which is how we report job gains right now.
And the two-digit would provide, I was thinking of asking also for what tiers they're on the unemployment chart, but maybe the two-digit codes could, I mean, because basically, if hospitality is going to look different than construction and so on. So basically, you get an idea of what kind of earnings they're getting by what type of classification they're in. So that might be good enough. Yes.
Yeah, like the generality on hospitality would be that lodging and restaurants are both in that same group, and then you break it down and you can get different types of restaurants, and lodging could be broken out. But once you do that, again, your data, you're getting into smaller and smaller groups, right?
So how we calculate that.
Right.
And the other thing that I don't, I'm trying to figure this out in my head, if there was a major layoff somewhere, which would say there's another company side of the labor chain, all of a sudden, you've got a community, great number of people up there, transitioning then back into the economy, is gonna be, maybe need more time. So I'm not sure how this would accommodate, some major layoff in some community somewhere. And I'm basically thinking out loud, I haven't formulated that very well.
First the seasonal one, and then the individual layoff one. The individual layoff one, it would depend upon how you set the triggers, right? And whether or not that layoff was of a size enough where it impacted the trigger or not. But you'd have different regions of the state having different experiences. All right now that have to figure out how to take that into consideration. On the seasonal, I mean, you have those seasonal filings right now. someone comes in with a seasonal layoff, if they have a return to work date that is within 11 weeks is what the statute currently is set at. If it's less than, no greater than 77 days, 11 weeks, they don't have a work search requirement. But again, they have to demonstrate that they have a locked-in return to work date. That gets verified with the employer. And they file during that period without having to search for work. If their return to work date is 78 days, they have to look for work the entire time period. So that's how the seasonally impacted employees currently interact with the system.
Representative LeBrie? You had a couple statements?
I do, but they may be just for us.
Okay. So we have a little bit of work, and we look forward to what your suggestions are to get us to where we want to be.
So I'll get all of that. I'll get a breakdown. We'll start with, I think 2024 is a good sample, and looking at the number of people filing at all of the different durations. Get it broken down by manufacturing, hospitality, construction, all of that. Get that to you, and then and also, do you want me to go ahead and have Brian's group do some work on weekly volume and seeing what type of factor they need to apply so that the Great Recession numbers are equalized to the growth in the labor force, so kind of on the same level as what 3,000 still means 3,000, 4,000 still means 4,000.
Right, that area. And then if we need to increase the trust fund to get to the 50% of the 60,000, and where we would have to adjust those triggers without raising the 14,000.
Okay.
Those would be the three big areas for me that would, because if we're having to borrow money, I don't want us to get to a point where we're borrowing money from the government. But if it's something that's out of our control, that's huge, we're gonna have to borrow, which we don't want to, but I think we've only had to do that once since you've been around.
We had to borrow right when it was just prior to me when I started. I wasn't in this job. I was a lawyer in their legal section. They borrowed in 2009 and then again in 2010.
That was, because we were swinging at the bottom of that
Yeah.
barrel for a long
And
time.
then with the reforms that the legislature made, New Hampshire was able to pay it back so quickly that there was no cost to any of that borrowing. Incredibly lucky, right? You don't want to have to take a Title 12 trust fund loan because it's going to be expensive to employers.
Yes.
Ask Massachusetts right now.
Yeah, they're $4 billion in the hole, right?
So they're already trying to get their trust fund to actually grow because they depleted it, borrowed during the pandemic. They initially borrowed, I think, $2 billion. They then bonded it so they wouldn't have the increased costs associated with the borrowing costs to the feds, but they have the debt service on the bond that the employers have to pick up. And they have $2 billion in benefits that they now need to pay back to the federal government for benefits that they paid using federally financed dollars that should have been paid using state financed dollars. And they reached an agreement that requires the employers to come up with $200 million a year for the next 10 years.
Outstanding.
And so when I say that they pay, and Massachusetts employers pay triple the rate on average in unemployment compensation taxes, New Hampshire employers, that's before factoring in this additional $2 billion that they just got tagged with. So that's going to go up.
That's why we want to do it the New Hampshire way. Thank you, Mr. Labors. Any further questions for Mr. Labors?
Thanks, everybody.
Yep. And thank you for hanging with us this long. Yep. Oh, no worries.
Thank you, Representative Avalani and members of John Reynolds from NFIB New Hampshire. I'll just be very brief because I know I've been at this a while. Just a few quick points. One, right, whether or not the tax burden or the unemployment insurance taxes pose a burden for employers, I think, like I testified back in January or February, kind of depends on what type of employer you are, your experience rating, how many employees you have. But I think it's important to know that, it is a burden for small businesses. So just because you have 10, 15, 20 employees, right, the unemployment insurance taxes can become a burden if you are in a high utilization industry. You don't have to have that many employees for it to be a significant amount of money to you. So that's going to vary. I think where there's a universal concern for our members, right, is the average claim duration, the average length that somebody's on unemployment, because the other point within those, first 2 or 3 issues that I hear from every employer member of ours, right? Tax burden, overall tax burden, which they view as high. So just because unemployment insurance taxes are low for some doesn't mean that, it's a reason to raise them on New Hampshire small businesses. Workers' comp is one of them. And then obviously finding workers, which I'm sure you hear from employers in every single one of your districts and across the state, right, is a huge issue. So how any change to unemployment insurance benefits affects the duration is of significant concern to them. With respect to, there is, at least in theory, an optimal replacement rate that balances the interest of employers and employees and getting back to work and taking care of people who are down on their luck. I'll point to one, University of Chicago working paper that was published earlier this year that showed 29% on average is the optimal replacement rate, which is where the state was, at least as of 2024 second quarter. There's another paper that I'm blanking on the source of it. I think American Economic Journal said in times of low unemployment, 33% is optimal on average. What that number is in New Hampshire under the current circumstances, I think it's a policy question for you all, but I think we have to have a good understanding of what the impact any change in benefits is going to have on the duration. And I think you all, based on the conversation, are pretty interested in that, which is a good thing. The other thing I think you should probably consider, right, is we credit to the department. I think we have the 4th lowest fraud rate in the country. It's, I think, like a third or a fourth or a quarter, third to a quarter less, 3/4 less than anyone else in New England. With the lowest in New England, 4th lowest in the country. Obviously, as you increase benefits, you increase the enticement for the potential for fraud. And I'm not talking about people who are down on their luck or, individual workers who are hard up. There are sophisticated networks of people who commit fraud, both inside and outside this country, that prey on states with very generous benefits. Massachusetts is, I don't have it in front of me, but I think Massachusetts is, our fraud rate as of 2023, 2024, which are the most recent numbers I could find, was 0.47%. Massachusetts was 8.28%. Significant difference. Even Vermont, which I think is the next lowest average replacement, I think, or I can't remember if it was max benefit or average replacement, their fraud rate is 4 or 5 times what ours is. And that doesn't include overpayments or underpayments, right? That's straight fraud. And then just the last, Representative McKenzie, to your point, right, about, so if you did a tier, if you staggered the length of benefits based on economic conditions, which about, I think, 8 or 10 states do, and there are states that experience, weather-related employment disasters, economic-related employment disasters, like North Carolina comes to mind. They're one that staggers the length of unemployment based on, I believe, the unemployment rate. They just went through, obviously, a horrendous hurricane. I think the state opted not to increase the length of benefits. They did add on an additional amount to people, right, in the affected areas. So there are triggers within those states to adjust for specific circumstances. There are also federal programs like, you know the name of it better than I do, but the trade basically trade exposed, yeah, assistance, right? Which can kick in. I don't know if that necessarily would have applied to the folks up in Berlin at the time, but I know that there are, yeah, lots of, right, there are lots of circumstances where that does kick in to account for the fact that it's not going to be easy to replace those workers. And that would also kick in, right, once the state benefits are exhausted, regardless of the normal length of those benefits. So I think it was a really, from my perspective, fantastic discussion. I mean, interesting. It's great that you guys are, taking a really serious deep dive into, right, how even modest increases in benefits impact the overall employment picture in New Hampshire. So on behalf of our members, I really appreciate you taking this seriously, and being cautious and careful with it.
Thank you. Any questions for Mr. Reynolds?
But I never hear the business community talk. It's the $112 million. The government of the state of New Hampshire deposited in the and the impact that it's had in postponing any kind of rate increases. Yet I've never heard a business come before this committee or any committee. But that it comes. That's why it makes sense.
Are you, Representative McKenzie, are you referring to during the pandemic era? Yeah. Right.
Postpone any increase in employee contributions that raised the funds almost $375 million. 660. So that was significant contribution.
Yeah, I'm sorry.
We got business had nothing.
Well, there was a significant expansion of benefits during the first year and change of the pandemic, the federal level, and the depletion of the trust fund, right, was caused by forces that were beyond an employer's control in the terms of a medical disaster, and also state restrictions that were the decisions of policymakers, right? So those were forces outside of the employer's control, and a number of states use federal pandemic assistance CARES money to replenish the fund to avoid those consequences. They also took other steps like freezing an employer's experience rating and all of that, right? Because again, that was a circumstance that was beyond an employer's control, which is, unemployment is really employers paying for circumstances that are at least somewhat within their control.
Follow up?
So the average employee pays $85 per employee is $850. You think that represents, and what they get for that, they cover their employees, potentially keep them in the workforce, keep them connected to the workforce, and maybe bring them back. So, but you think that's too expensive for what's? I'm trying to figure out. It's pretty low amount of money.
Right, Lynn. I mean, I'm not here to argue for the abolition of the unemployment insurance system. No, and like I said at the outset, the extent to which unemployment taxes impact, the finances of your business, I think depend on your utilization rate, how many employees you have, right? My point earlier was you don't have to be a big business in order for the taxes to pose a burden for you, a financial burden, because if your average employee hit is $150 or $200 or $250 and you have 15 or 20 employees, that's a substantial amount of money. And no, I mean, our across the board, right, the interest that our members have in this issue that affects all of them is how long are people going to use the program on average, right? And that's why I think we should be careful, because we have, I think right now, close to 2 job openings for every 1 unemployed person in the state, right? And that's a precarious position. It's difficult, to find workers. So if you lose one, it's a problem.
Thank you. Any further questions for Mr. Reynolds? Thank you. Mr. Lavers, you want to rejoin us? Certainly.
It was 109 million in CARES Act dollars that were over, not all at once, or gradually were put into the unemployment trust fund rather than those dollars going back to DC. So that was a decision from Governor Sununu that dollars that were unused by their initially designated program, whether it be Main Street Relief or whatever other program was set up, those dollars that were not used for their original purpose, those dollars went back to the trust fund to the tune of $109 million in total. Only other point I wanted to make is that employer experience during the entire pandemic period for New Hampshire employers was frozen. So none of the benefits paid out, either federal or state, during the pandemic had any impact on employers' experience rating for that from March of 20 through June 19th of 21. So none of those were factored against the employer's experience.
Correct. The only point that we had, I'm sorry, the only increase we had was the following quarter when in January of 21, when the trust fund was down, everybody lost their rebates. I don't want to say rebates, but
Correct.
lost their
Yeah, so
experience
those,
points.
so as the trust fund dropped, because we were paying about 50%, so we paid about $350 million in state unemployment, about $350 million in pandemic unemployment, and then the rest was that $600 a week additional that the feds paid to bring us to about $2 billion. But as the trust fund was dropping, you're correct. Employers were losing their fund balance reduction, so their rate, even though it wasn't going up as a result of experience, because that was frozen, they were losing those reductions. One change that the legislature did make in one of Governor Sununu's budgets, because it was included in House Bill 2, was we got rid of those half-point surcharges. Right? So when we adjusted the fund balance reduction amounts from to where they're at now, 250, 350, 400, he also got rid of the surcharges that kicked in and increased your rates more when the economy was going down, and it's probably the hardest time to pay. So those are gone.
Yeah, because I remember that bill in January was,
Yes.
it was, yes. All right, thank you. Any
Thank you.
further questions from Ms. Lavers? We're good? Thank you. Thank you, gentlemen, for joining us today. It was very robust and for the cordial discussion. You want to have another one of these, or do you want to wait for Mr. Lavers to get back to us?
Let me talk with some folks.
Yeah.
See how quickly we can put the easier one, probably within 2 weeks, we can have the query with the duration breakdown. The other one on equalizing the weekly volume for all different cycles of the economy, that will take a little bit more time. I need to talk to the economists and help me figure out how quickly we can do that.
Understood.
Are we going to stick to Tuesdays, seeing how that's our usual committee day?
I have no problem with that, and we're only here until next month.
Really?
Yeah, 22nd.
Yeah, after that, so, Mr. Lavers, if you
We're
have,
not gonna be in the building.
I'm not gonna be in the building, I don't know where.
Well,
Bonnie would-
we could possibly get a room over at the State House.
Good.
It's, I think, June 1 when the speaker shuts things down. I think.
I think it's fairly close, yeah, because I know they're
Or
gonna.
it might just be July and August. I think it's July and August that he shuts down. But this building is not going to be accessible.
Yeah, but we'll
So
find someplace.
it can't be just someplace.
Well, we'll be here somewhere. If it goes beyond mid-May.
Yeah.
We have to take that time.
Um,
But I think just one more, you think, and have another discussion? And
Let's have another discussion and see if there's anywhere else to go from there. And then the other odd thing about,
Certainly.
and the other odd thing about where we're at is that, as you said at the outset, we're looking to see if there's a bipartisan bill that we can come up with.
I'd like that. I know you would too.
Well, I think that's the only reason we're here. Because basically, otherwise, the state of affairs is that any one of us could file a bill next September because of the tabled bill from this year. But I think the seeking consensus is always a good thing. So I want to continue doing that and see if we can find it. And I don't know if Representative Labrie had something to add.
Certainly. Most certainly, yeah. We can.
It's still an open meeting though. Okay, yep.
Thank you, thank you. Thank you, Mr. Lavers, for
Thank
being
you.
with us. Thank you.
I do have a hearing to get to at 1:30, and I would love to get some lunch. He'll come back. And I think we're still, are we on camera? I think we might be. Yep. I just want to make sure that we know
Good
that.
to know.
Yeah.
Always good to know. This system is about integrity and honesty. And when the system is manipulated and people are collecting when they shouldn't be collecting or putting forth false stuff, that really, it's almost like an election integrity in a way. It really undermines it and it puts a bad taste in everybody's mouth, including employers. The way that Mr. Lavers said that it was monitored is scary. It's a little bit loose. You get 3,000 people collecting, you get a very limited staff vetting. And I think we all heard that. I don't think that's disputable, okay? Now, to what levels, who knows, right, really? I'm all for a little bit more money, but with more accountability. And from a bipartisan bill perspective, that's where I would land. I don't like the ACH feature. It's too convenient. I get the argument. You can't always get there to get your check. I understand that. This is not meant to be convenient. This is meant to be a lifeline. That's how I see it. I also think if we could come up with, and he spoke to it, that they've already funded for this and that they're going to have some AI assistance with the vetting. If we could get more AI accountability and become more strict with accountability, delete ACH, I would not be opposed to increasing weekly benefits. That's where I'm at with this. In my opinion, this is a give and take.
And just to be clear, we're not talking about increasing weekly benefits for everyone. For everyone on the current table, the benefits will remain exactly the same. It's only for people beyond the end of the schedule, to a limited extent.
Correct. I'm sorry. That's
Yep.
what I meant. Yep.
ACH portion, I want to say it was a cost reduction at the time because the price of checks was getting a little expensive at the time. I want to say it was probably early 2000s maybe when they went to ACH. That would have to be factored in because there would be, we'd have to bring back that portion of it to cut live checks to everybody.
I think everybody's doing direct deposit. I mean, my Social Security certainly comes that way. I do have the option of a check, but I don't think much of anybody takes that option. It's cheaper and easier for everybody. And I don't think we need to make it harder for people to get the money. I don't disagree with making sure that it's all on the up and up, that it's make it harder to cheat. I don't think that many people are, but if there are some, and I think I really like the sound of the AI work that Lavers is looking to do. I've been playing around with ChatGPT, and it's fascinating, a little scary, but basically you can really drill down and get data that's not readily available otherwise. You just ask a simple question,
Right.
and all of a sudden, the data comes piling in. So it's I think using that can customize the experience and get people excited about what opportunities are out there for them because we talked about drop downs and that type of thing where and not everybody's good at looking for work. I remember when my son was at RIT, he had to do a co-op. You know, we would ask him to go out and work for a semester. And he was almost in tears with me saying, Dad, I don't know how to do this. And I said, Pat, neither do I. But you're surrounded by people who know how to do it. You just have to use the resources. But I think there are people, you know, in all walks of life, they're in the same spot. I mean, he's a smart guy. He's in good shape. He's doing computer engineering now. I mean, he's not, but he just didn't have the job search skills, and he was too introverted to actually take advantage of what the university had. But at any rate, I think a highly interactive online system that really gets custom designed to help people find work will make a huge difference. I think people who are lost might be found.
Understood. And good points, all. I just am one for in-person accountability. I believe there's no substitute for it. And I believe when you go to one of these locations, you ask for your check, no problem, here's your check. You got to tell me where you're at with stuff. And whether that's an AI portal that's at the facility or it's a real person or whatever it is, I understand there's expense to cutting checks and it's more expensive and less convenient. I'm not trying to create a blow on the employee. I'm just trying to make it so that there's motivation and accountability. That's all.
And I hear you. I don't disagree with you, but I think making someone drive perhaps 100 miles to get a check is a drain on resources that are very limited when they're getting very little compensation to start with. And some of these folks don't have the ability to travel. They don't have cars. You know, at the lower end of the scale, they might not be able to get there. They don't get the check then. So I don't think we want to do that to folks. We can find accountability in other places.
Yeah, we can find some accountability. We can have Mr. Labors maybe come up with some ideas.
Yeah, well, he's got some.
He's got plenty.
Yeah.
I like to have it cultivated from the department and then we put our stamp on it.
Uh-huh.
Of course.
I mean, I served on the unemployment committee for years. So I can tell you that they have a robust legal department. And you know, when we first were doing this work, we used to go for tours.
Mhm.
You know, we go to the department, to the
Yep.
labor, and go. And I suggested that to the chair because I don't, you know, somebody that just started through this process needs to understand kind of how that operation of thing works. You know, we've not exposed to it like we maybe had been. But there aren't too many people slip through. There's one exception during COVID. They had some issues.
Yep.
And they had to rake back a bunch of money. That was at a time when there were thousands of people in employment. They just
And all their offices were closed.
Yep.
You know, it was a mess, but I'll tell you, Labor's pulled us through that.
Yeah, he's phenomenal.
Which is fun, you know, fun. It's very Peter Locks.
Yep.
Fun, it's a lot of money.
Yes.
He gave every rep who wanted his cell phone number. Any one of us could call him.
Yep.
And when people did call, he personally made sure that that issue, you know, you've got a constituent who just can't get through the system because it was a disaster. He would make sure that someone reached out and took care of it. It was truly amazing. My respect for this guy. What's guy? Yeah. But he wasn't the face of it.
Oh, he was all over. And anytime we reached out to him for anything, he was very responsive. I
Yep.
think we stopped the tours through COVID, and I think that we should probably restart those at some point. I think that was, yeah. Remember, we went to we had lunch at DOL when I first came here. Then we went to unemployment insurance. It was a good tour.
You know, the only other person there's a workers' compensation that meets, I think, and the guy that's the chair, I think he's the chair, state rep. And he was here during all these changes that took place in the law. He's the only, probably one of the only guys. But there is a committee, and you know, the unemployment takes this stuff up. I don't know what they workers' compensation. So I don't know, I mean, but maybe at some point we're not on the committee. Legislation. I don't think we have representation. We do on the.
I think Brian's on it. Seaworth is on the workman's comp one.
I think there is, yeah.
I think he's on it because, yeah, I thought they tapped Susie for that.
They did,
On the
but I
phone.
don't think it continued.
I don't know who it is then.
We know that public session. We told them that issues we want to raise.
I like it. We're all done, yeah. Thank you.